My learned friend.
He's trying to teach me bad manners. He's trying to teach me bad manners.
His father was our friend, senior friend. Well, this order was passed by your lordship on the last occasion. It was taken out, item number 9, it was in the list.
Oh,
The
7.
clients are coming from Kuchbihar. It is well 49.
আজকে তো এটা আসার কথা ছিল।
It has come, but it is at the bottom of the hearing list. 49. Well, it is ongoing hearing. Kindly update this matter.
49.
Yes. Kindly update this matter. 20% hearing is already over. There is judgment of Supreme Court, Lordship. Kindly.
Okay, it would be updated
Tomorrow.
tomorrow. Okay, let's see.
May I have your lordship leave to mention item number 10?
Yes.
Madam, for the petitioner, Mr. D.N. Roy is appearing for the BSF. But today, that day Mr. Roy was not there. But today, my lord, I am in very much difficulty. I have spoken to Mr. Roy. He has no objection if your lordship has
Not today?
kindly takes it up any day next week.
Not this week.
Lordship.
Okay, not
Lordship. Mr. Roy is available next week.
Okay.
May I permit to mention one matter? This is, my lord,
It will be in the same position.
Okay.
this is extremely urgent. My lord, item number 470 of monthly list. I mentioned before, lordships, my lord, petitioner's father is suffering to cancer. My lord, the petitioner want to join. My lord, he is serving as a primary teacher. Due to my 2020-23, the FIR lost. And my lord, this is offense outside of this, my lord, service. My lord, he enlarged this bill. Since 2020-23, my lord, he could not join. My lord, only, my lord, I may...
He is getting subsistence allowance.
Yes, yes, that
Whether
subscription.
he has been placed under suspension.
Yes, suspension. That's why the suspension, my lord, that's why my humble prayer, my lord, the primary school council, my lord, not allow unless, my lord, the honorable court is
He is
passed.
getting something.
My lord,
He is
this
getting
is, I need to some interim order.
Interim order will be final relief.
Yes, my lord, that any time, my lord, say kindly
Interim
before.
order will be final relief to direct them to allow you to
Only that, only to
It is
prayer.
your final relief.
Any condition imposed by your lordship, my
Cannot
lord, the
be
petitioner
given
will abide by.
in-
My lord, kindly allow me, kindly, my
It
lord.
should be upgraded. If
My lord.
give them the slip, it will be upgraded.
My lord.
My lord, may
Upgraded.
I
You are
comment?
getting something. There are many person who are getting nothing.
Yeah, that's why, my only for to upgrade before your lordship,
Okay.
nothing else, my lord.
Many
So,
person has been
my lord, another, my lord, for
from service, not getting pension. One by one.
and another, my lord,
Okay, it should be updated.
my lord, this matter
Another
is,
matter, today is not mentioning date. I have
no, for inclusion in the next month list, nothing.
next month listening.
My
I
lord,
have given prior notice to them.
my lord, may I permitted to mention for withdrawal of this matter, my lord.
Okay, to be mentioned.
My learned senior already mentioned this matter, but not come in the list, my lord.
এই দেখুন তো এটা কি হয়েছে।
I'm-
To be mentioned, to be mentioned. To be mentioned কালকেই দিয়ে দিতে পারেন। হ্যাঁ। বেসিক্যালি স্টাফ সব তো সাজানো হয়নি তাই তো নাকি না হয়েছে। ওকে ওয়েট ফর সাম টাইম ইট উইল ডু হ্যাঁ।
Mention on hearing matter inclusion in the list matter. Pending since long time.
No, wait for some time. If extreme urgent, what is the urgency?
The national.
I know many matters pending. Okay, I have stated many members of your association that many matter has already have been included. Allow the court to dispose of certain amount of the matter. Thereafter, again it would be included.
Monthly list, madam.
Monthly list, thereafter monthly list, my list would be so adjourn means it will be go at the bottom. Okay. Okay, I mean,
Lordship, may I be permitted? I am mentioning this matter upon service, Your Lordship, for extension of interim order.
when it will expire?
It will expire in course of this month.
In course of this month?
Yes, Your Lordship.
Achha, this month they expire. Good.
Two identical matters.
Yes.
Gradation list has been prepared. Disregarding the date of promotion and date
Hearing matter?
hearing matter, it is
Month of June.
kindly
Combined list of June.
Lordship, hearing matter, my lord, inclusion for in the list, my lord.
What is the urgency?
Article, my lord, petitioner's 10 years benefit has not been given, my lord.
Huh?
10 years benefit has not been given, my lord. That's why financial loss.
Monthly list of June.
June.
Monthly list of June. Give.
Matter was, Lordship directed the matter to
Today it didn't appear. এই ওটা দেখুন তো আজকে অ্যাপিয়ার করবে বলেছিল অথচ আসেনি। Tomorrow 2 p.m. booked. 2 p.m. every day booked. Mention tomorrow. Tomorrow is the mentioning date. Mention tomorrow. Have you given notice? I give notice and mention tomorrow.
Maybe one minute. Well, item number 9 and 10. All right, if you lost takes up the matter at 2 p.m.
2 p.m. I don't know whether 2 p.m. any officially fixed matter or not.
My lord.
So I am making not today.
No, I will do it. I will do it, my lord.
9 not today, my lord. Not 10 not today. 10.
Yeah. Yeah. No. No. My lord, review matter.
Review matter, will you do it today?
Yeah, on the last occasion, he also directed me to serve the other side. They were not present in 2 days. And I have served the other side, and my availability of service, my lord, is awaiting for my lord in the section, my lord.
So come tomorrow. If you are in a difficulty today,
All right,
so come tomorrow.
tomorrow at 2 p.m., my lord.
2 p.m.
All that, my lord, in the first half.
Okay. Yes.
Same position.
Not today. Yes,
My lord,
not today. Okay.
Look, today, item number 70, with your kind leave, if it can be fixed at 2 p.m., the urgency is that the registration is valid till today of the big pharma company.
My learned junior friends live, my lord. Item number 70, my lord, I have mentioned for last 2 days, my lord. Kindly recollect, my lord, the registration will be.
It has not been called.
But item number 70, no, my lord. My lord, if it could be possible to taken up at 2 p.m. or 3 p.m., my lord, with my lord's subject to convenience, my lord, I shall. Mr. Shuman is appearing for the council. I shall inform him, my lord.
Tomorrow is the last day.
Tomorrow is the last date, my lord.
Okay, bring him.
Very good, my lord. I shall come at 2, my lord, then.
Yes. Upgradation, wait for some time. What is the urgency? Okay, wait for some time.
May I?
Okay, wait for some time. It would be given retrospectively.
Item number 4, today's list. Well, today I am little bit handicapped because my junior and clerk both are on leave. But
You are for the petitioner.
I am for the respondent.
I am the petitioner without notice, my learned friend mentioning the matter.
No notice, it is in the list, Millard.
Whatever it is, you should inform me. You are my learned friend.
And I am
Sit
here.
in my chamber behind.
Millard, I can even wait till the
My
call.
learned
Okay,
friend is
today
sitting
he is in
my
difficulty.
chamber behind.
Yes.
Today is difficulty. Come tomorrow.
Millard,
Lordship, no.
Millard, can I come on 15th? If my
15th,
learned friend-
specific date.
15th.
15th, you are for the respondent.
Yes, Millard. If my learned friend agrees.
Lordship, 15 is too much. Make
The
it,
next week,
make it
make it convenient to do it in the next week, not this week.
Tuesday is 14th. I was praying 15th. Tuesday is 14th. I was praying 15th. That much, Millard. If my learned friend can.
Okay, the 15 এ করে দিন। 15 come on 15th. 15th এটা ইয়ে করে দেন। Date দিয়ে দেন।
There is the interesting matter, Millard, where resolution has been passed by the
Yes, after the writ
CLT.
petition, they have filed an application.
Lordship.
In
The
application,
petitioner has got interest. Let whether court got interest.
Lordship,
Yes.
Okay.
Without Lordship intervention, Millard, resolution cannot be passed.
Oh,
There is a proposal.
okay, come on 15.
We will
Come
come.
on 15.
15th day.
Get ready.
God bless you.
Yes, yes, next.
These measures were already updated last month from the month. It's not running regular. On 5th of this month, the matter again divided into the month. Subsequently, there is no.
Anyone took adjournment? Anyone took adjournment?
This matters are running at the head for hearing. 9121.
আচ্ছা ঠিক আছে okay give it I am reshuffling the list, follow the list. Today returning matter, tomorrow it will be taken up any day. Okay, get ready. Next, call the list, please call the list. Item number 1, non-agree. Correction. এই সুমন বাবু, এই দেখুন 22টা 20 করে ফেলেছে, করে দিন। হ্যাঁ 22 সালটা 22 হবে 20 হয়ে গেছে। হ্যাঁ ঠিক আছে, নেক্সট 2 yes.
Well, I appear for the petition.
Yeah. For the petitioner, Mr. Bhattacharya.
Yes.
Mr. Senior
Let me
Advocate,
comment
Mr.
my submissions. He is going to join.
Huh?
Mr. Pradip Kumar Roy is appearing for the restaurant, my lord. He is in another division, means 13. So kindly give me a short passover, only for 5 minutes. Only for 5 minutes. Short passover.
Let me comment. Otherwise, my upper primary matter
5
is
minutes,
fixed
my
at
lord.
go to number 17. It is already, the honorable judge has said it is item number 1 there.
Just one minute.
So not today, come tomorrow.
No, sir.
Huh?
Only for 5 minutes passover. I am paying for only for 5 minutes.
Well, very good. At 2 p.m. then.
Today.
Today at 2 p.m. Because 2 p.m.
PM.
already I have 189. So I think I should be here.
Okay, come at 2 p.m.
Very good. Okay, Mr. Roy is here. Let me comment.
Oh, yeah. You want cancellation of a tender process pursuant to such and such after finalizing the fee as opposed to public. Yes.
And the only short point for consideration is there are 2 tenders which were floated. One in the month of March, the other in the month of June. First cancellation, I did not take steps with the idea that they are going to float a fresh tender. In both the tenders, in the second tender, apparently, I am L1. Why L1? Because, I have offered a better rate as commission to the government. They are going to garner more revenue as against all other similarly circumstanced these way bridges which are functioning in the state of West Bengal. A good, bad, indifferent by a one-liner, they have declined to proceed with the tender by saying that the tender has been cancelled. Now please see the impugned order. Page 116.
Yes.
The above tender, e-tender, has been cancelled due to administrative reasons. Now, in their affidavit, kindly takes their affidavit. This is the short sum and substance. Please take their affidavit.
Yes.
Please come to paragraph 18.
Yes.
Before I show you, Lordship, paragraph 18, please come to paragraph 19 of the writ petition.
in paragraph 18, I have pleaded about the document which I invited my lord's kind attention to. That is page 116. I invited my lord's attention, cancel the tender process citing administrative reasons. That is paragraph 18. In paragraph 19, I have said that the petitioner number 1 through the petitioner number 2 by several representations lastly dated such and such ventilated their grievances before the respondent number 2 and also other authorities, but such representations, in spite of receiving, was never replied to or considered. Now, this is, and I have annexed photostat copy of the representations. In response to paragraph 19, in paragraph 18 of the affidavit in opposition, page 4, my learned friends, clients have said, with regard to the statements made in paragraph 19 of the writ petition filed by the petitioner, while the petitioner did submit 2 letters, the respondent had already informed the petitioner through the website that the petitioner was not selected due to administrative resort and issues. Now, these administrative reasons has not been disclosed. What is the administrative reasons? What is the basis of the administrative reason? I can take, a particular decision which, is kept up their sleeves. They don't disclose the reason. But reasons, as your lordship very well knows, are antithesis to arbitrariness. Reasons spell, something beyond. It spells life to a particular decision. If the decision is administrative reasons, then your lordship has, perhaps with greatest of respect, has got to look into what was the reason behind such administrative reasons. In my most respectful submission, apart from saying that this is an administrative reason, now, one question which might crop up, it might fall from your lordship, that this is a decision of the highest authority. How can you challenge it? Now, in my most respectful submission, if a decision is, without reasons, and if a decision is, not disclosed to the parties, then, such a decision, apart from being anything else, becomes an arbitrary decision. Now, I respectfully say this to your lordship, that at page 117, yes, 116, I invited your lordship's attention. 117, the tender was cancelled, and you may, visit the website for further decision. Now, this website, on paying a visit, nothing was available. Now, what we are respectfully submitting to your lordship is, in their affidavit, they have disclosed only one document, that is, the decision that the managing director is going to defend. Now, 88.4 SCC. Yes. Now, this is a writ petition. This is a writ petition, and the decision, I have invited your lordship, the impugned decision. Now, please come to 88.4 SCC, page 531, 534.
কপি আছে দাদা?
দিচ্ছি, আপনাকেই দিয়ে দেবো।
1988
4 SCC 534 kindly comes to page 542. At page 543, I read from the third line from the top at page 543. Before us also, no particulars and no facts have been given in the special leave petitions or in the writ petitions or in any affidavit, but the point has been sought to be substantiated at the time of hearing by referring to certain facts stated in the application by H.A. IDC. In our opinion, this is important and this is a very celebrated pronouncement. In our opinion, when a point which is ostensibly a point of law is required to be substantiated by facts, the party raising the point, if he is the writ petitioner, must plead and prove such facts by evidence which must appear from the writ petition, and if he is the respondent, from the counter affidavit. If the facts are not pleaded or the evidence in support of such facts is not annexed to the writ petition or to the counter affidavit, as the case may be, the court will not entertain the point. In this context, it will not be out of place to point out that in this regard, there is a distinction between a pleading under the Code of Civil Procedure and a writ petition or a counter affidavit. While in a pleading, there is a plaint or a written statement, the facts and not evidence are required to be pleaded. In a writ petition or in the counter affidavit, not only the facts, but also the evidence in proof of such facts have to be pleaded and annexed to it. Now here, in this entire affidavit, your lordship will not find any annexure which would persuade your lordship that yes, Mr. Petitioner, there were justifiable and justiciable administrative reasons which prevented them from proceeding further with the tender and warranted a cancellation of the tender process. There is nothing in the affidavit. So I would request your lordship, in the light of the judicial pronouncement, sorry, not copying. Now, my lord, this is reported in 2024 SCC online 1682.
Yes.
My lord, kindly straightway come to this issue has been dealt with in 11 in paragraph F, this head note F, points for determination and analysis.
Yes.
Now, my lord, please come to just give me 2 minutes. Here also, points for determination would appear from page 11.
The page number.
Page 11, internal page 11. This pagination your lordship will find here.
Okay, yes. Yes, I am on page 11.
Points for determination, what is the scope of judicial review?
Yes, yes.
Of actions of the state in the matters relating to contract disputes under the writ jurisdiction. Now, my lord, G is the analysis. My lord, over the years, the scope of judicial review, the extent to which the court can interfere in disputes arising out of contracts or tenders has been significant development marked by nuanced understanding of the critical role of administrative discretion. The judicial quest in administrative matters has always been to find a right balance between allowing a leeway to the states in deciding the exercise of their administrative discretion in matters pertaining to policy, the need to ensure fairness and propriety in such administrative actions. Now, my lord, thereafter the case laws have been discussed starting from Radhakrishna Agarwal. My lord, it is in the realm of contract. Now, my lord, straightway kindly come to internal page 27. Well, I request, my lord, I am very sorry. Kindly come to internal page 26, paragraph 58.
Yes.
Thus, the demarcation between private law element and public law element in the context of contractual disputes, if any, may be assessed by ascertaining whether the dispute or the controversy pertains to the consensual aspect of the contract or tender in question or not. Judicial review is permissible to prevent arbitrariness of public authorities and to ensure that they do not exceed or abuse their processes, but their powers in contractual transactions, and requires overseeing the administrative power of public authorities to award or cancel contracts or any of its stipulations. Therefore, what can be culled out from the above is that although disputes arising purely out of contracts are not amenable to writ jurisdiction, yet keeping in mind the obligation of the state to act fairly and not arbitrarily or capriciously, it is now well settled that when a contractual power is being used for public purpose, it is certainly amenable to judicial review. Then, my lord, paragraph 62. Paragraph 61. Thus, the respondent could be said to have exercised powers in its executive capacity as the action to cancel the tender falls outside the purview of the terms of the contract. Hence, it cannot be said that the present matter is purely a contractual dispute. It is also not a breach of contract, as no such breach has been imputed to the appellant in terms of the contract, but rather a plain and simple exercise of executive powers. Thus, the present dispute, even if related to a tender, cannot be termed as a pure contractual dispute, as the dispute involves public law element. Although there is no discharge of public function by the respondent towards the appellant, yet there is a right to public law action vested in him against the respondent in terms of Article 14. This is because the exercise of the executive power by it in the contractual domain, that is cancelling of the tender, carries a corresponding public duty to act in a reasonable and rational manner. Thus, we find that the writ petition filed by the respondent was maintainable and the relief paid for could have been considered by the High Court in exercise of its writ jurisdiction. So therefore, my lord, I respectfully say, having regard to the dictum made by this judicial pronouncement by, my lord, a 3-judge bench of the Honorable Supreme Court of India, my lord, I respectfully say that this cancellation on the face of it is illegal. It is just to prevent me from, my lord, doing my part of the business, where ultimately, my lord, the state would have benefited, the authorities would have benefited, because I have offered them a better, my lord, revenue, a better, my lord, offer in the form of revenue. So, my lord, I respectfully say, having regard to it, may be argued that we have completely dispensed with this entire scheme. The government has decided, but the issue which falls for gracious consideration by your lordship's court, my lord, as to whether in the event your lordship is with me, then the cancellation goes. And if the cancellation goes, let them produce whatever records they want to prove by way of, my lord, I need not see it. Your lordship satisfies your lordship's judicial conscience that there was justified reasons for cancelling. Administrative reasons, my lord, is a very blanket proposition. It may be any but someone feels that today the sun has not risen, so therefore it is an administrative reason, we can't proceed. So there has to be some conscious application of mind before embarking on this particular gray area, not in the form of not a contractual dispute. Because ultimately your lordship is in judicial review, not seeing the decision. Not the decision, but the decision-making process adopted by the respondents. If it is fraught with illegality, if it is fraught with irrationality, if it is fraught with, my lord, impropriety, then perhaps, my lord, your lordship has long passed, my lord, to set at naught those illegalities. My lord, kindly, my lord, my learned friend, Mr. Chatterjee wants me to place before your lordship another relevant paragraph. Please come to paragraph 65. Of this judgment, internal page 28.
Yes.
The meaning and true import of arbitrariness is more easily visualized than precisely stated or defined. The question whether an impugned action is arbitrary or not is ultimately to be answered on the facts and in the circumstances of a given case. An obvious test to apply is to see whether there is a discernible principle emerging from the impugned act, or if so, does it satisfy the test of reasonableness, where a procedure, the performance of the act, otherwise and in a manner which does not disclose any discernible principle which is reasonable, may itself attract the vice of arbitrariness. Every state action must be informed by reason, and it follows that an act uninformed by reason is arbitrary. Rule of law contemplates governance by laws and not by humor, whims, or caprices of the men to whom the governance is entrusted for the time being. It is tried that be you ever so high, the laws are above you. So, my lord, this being the judicial arena, my lord, I invite your lordship to kindly decide the matter kindly, my lord, if they want, whatever they want to, my lord, they can produce the entire, my lord, decision file before your lordship's gracious consideration. My lord, it is very easy to say that we have scrapped the entire project. The scrapping itself is also, my lord, because the law demands the Motor Vehicles Act, the West Bengal Motor Vehicles rules demand that way bridges have to function in the inter-district borders. Now, this is, my lord, the sum and substance of the writ petition. There is nothing else. My lord, I'm taking your lordship's leave. My lord, Mr. Chatterjee is here to assist your lord. My lord, this is the other judgment I have handed over to you.
Yes, yes, Mr. Rai. Yes, Mr. Rai.
My lord. My lord, I'm taking your lordship.
My lord, the challenge of two cancellation of tenders, once in March 2022 and one in July 22. Two different reasons for cancellations. And cancellation clause is inbuilt in the tender notice itself. But my learned friend was referring that the clause was not there, the judgment from which I have heard. So, my lord, here the clause of cancellation is inbuilt in the tender notice, where it is said that without any reasons, the authority can cancel the tender process. Now, my lord, in the March and in June, the tender was cancelled. And when the writ petition was filed in the on 18th day of May 2023. And he is asking for equity. Well, Lord, your lordship knows the delay defeats equity, because had he any positive case or any legal right infringed, he would have approached the court immediately after the cancellation of the tender process. Had it been done unjustifiably, unreasonably. But your lordship, from page 30, your lordship would found that this was filed on 18th day of May 2023. And this delay, whether that would defeat his right or not, whether there is any right in favor of the petitioner or not. In the order where, my lord, the interim order was granted, there it was categorically mentioned by the coordinate bench that the delay point in filing, that would be, my lord, hurled on, and that would be heard at the time of hearing of the writ application. So, my lord, if a man is aggrieved by any act of the state, having been participated in the process, without accruing any right until and unless the contract came into existence. Unless the contract came into existence, he has no legal right to challenge the cancellation order. Because when the tender process was floated, a lot of participants offered their price. That doesn't mean that tenderer has given guarantee of issuing work order in favor of X or Y or Z. It is the prerogative of the authority to decide the issue. There are so many decisions, even if there is lowest tenderer, the authority didn't pass any order in favor of him, the Supreme Court didn't incline to interfere. So, my lord, here one more thing, my lord. If your lordship kindly see that who is affirming the affidavit, kindly see page 30. This is a gentleman who is working for gain. I am the petitioner number 2 herein and authorized representative of the petitioner number 1. My lord, this is a private limited company. As per Companies Act, anybody cannot file, my lord, everybody cannot file, my lord, any legal proceeding until and unless there is a board resolution. So, my lord, here not a scrap of paper was filed or even disclosed that I am authorized by a board resolution to file this instant writ application. Though he in his averment, he said in paragraph, my lord, 1, that he is a principal officer, director of petitioner number 1. But in the affidavit, that doesn't reflect. So, my lord, at the threshold of this matter, my lord, unless a person is duly authorized by the company, he cannot, my lord, prefer any writ petition before this court for any sort of relief. Now, my lord, it is well settled position of law that merely by participating in the tender,
You have stated.
no right is accrued.
Yes.
And, my lord, the tenderer cannot be precluded from its option to cancel, precluded the tenderer from its option to cancel the tender process on any ground. My lord, I am referring that clause, my lord, that is page, my lord, 35.
Yes.
Clause 5. The Managing Director of West Bengal Transport Infrastructure Development Corporation Limited reserves the right to cancel the NIT due to unavoidable circumstances, and no claim in this respect will be entertained at any stage of bidding or even award of contract. If any inadvertent typographical mistake is found in the BOQ or any other tender document, the same will be so corrected as to conform to the prevailing relevant schedule of rate and or technically sanctioned estimate or any other document as the case may be. So, my lord, the candidate, my lord, the petitioner hearing, who has participated in the tender, knowing fully well the conditions of this clause 5, and he accepted that. Thereafter, he participated. So, my lord, he cannot preclude the tenderer, my lord, from cancellation of the tender in terms of clause 5. My lord, the tendering process thus can be cancelled at any stage before finalization and issuance of letter of acceptance, as there was no concluded contract between the parties. Unless there is any concluded contract, my lord, he cannot have any legal right, my lord, to challenge the same. It is also well settled that tender is only an invitation to offer, and the other party makes an offer pursuant to the invitation to offer. As such, it is not obligatory to the authority issuing tender to accept the offer, and no right is created on the basis of merely being a lie. Thus, the respondents were well within their right to cancel the tender before acceptance. A right would only be accrued when a contract comes into existence. The scope of judicial review in contractual matter is very circumspect, and the law with regard to interference of the courts in judicial review of the administrative decisions is well settled under Article 226 of the Constitution of India. My lord, here by order at the instance of the petitioner, my lord, an interim order was passed that no fresh tender could be floated. So, my lord, he has digged his own hole. And first of all, he challenged 2 tenders. One tender in March, he accepted the cancellation with good spirit, but he never challenged after the cancellation. Then he participated in another tender. So, my lord, he has waived his right from challenging the first tender. The second tender, that has not come to a conclusion. No contract has been arrived at. So, my lord, he has no right to, my lord, challenge this, my lord, tender process. And furthermore, the authority has the right to abandon the project for the moment because of so many reasons. And, my lord, and the authority, I will show you, lordships, that even if there is no detailed reasons, even then also the courts should go slow in interfering into the, my lord, domain of contractual matters. My lord, I am referring I will not bother your lordships with the judgments of the Supreme Court. There are Supreme Court judgment which was taken care of in a particular case of High Court of Kashmir and Ladakh at Srinagar, where, my lord, all the three judgments of Tata Cellular and other cases, the important cases, were taken care of. And যদি থাকে আমি দিচ্ছি তুমি এটা দেখে নাও এটা একটু দেখে নাও রেলেভেন্সটা there, my lord, the case was identical. Tender was floated and it was cancelled by the authority. Thereafter, my lord, the court found that it is not a fit case where, my lord, the judicial review can be exercised. So, without bothering your lordship with the cases reported in, my lord, 2008 to CTLJ and, my lord, 1995 AIR Supreme Court 11 and other judgments, my lord, I am only submitting that judgment because your lordship knows that how far the court can go in interfering with the decisions of the authority of the state government, my lord, in the domain of contractual matters. Here, my lord, second para, the contention of the petitioner is that, my lord, I am handing over this, is that they had fulfilled all the total formalities and participated in the tendering process, and being the lowest bidders were declared LI in both the ENITs. The respondents did not finalize the tendering process despite lapse of time, constraining the petitioner to approach this court by way of writ petition bearing number so and so.
Okay.
My lord, your lordship kindly go through
Yes,
that.
yes. Yes, got the point. You give the
My lord.
Yes, yes. Yes.
My lord, another
Next
judgments,
judgment.
my lord.
Yes.
Another thing, my lord, in the context of this case, my lord, had he been participated in the process, and his prayer is not to cancel the order. So, my lord, he could have approached the civil court for specific performance of contract. He cannot approach the writ court, my lord, for such relief. And he has also pleaded in different paragraphs that in order to participate in the tender, he has invested some money. And for that also, in the judgment of the Honorable Supreme Court, it has been specified that he can approach the civil court for damage. But he cannot come before the writ court, my lord, for any interference when the state has decided to abandon the project. And because of perhaps for his conduct, because had he been interested in the project, he would not seek for any interim relief. The interim relief that was to restrain the parties, the respondents, not to float any fresh tender. So, my lord, government has decided not to proceed with this scheme, and, my lord, so court cannot, my lord, with due regard, my lord, to the of your lordship, that court cannot insist or force the government that you do this or do that, my lord, in the matter of contractual matters, my lord. So this is my humble submission before lordship. My lord, may I mark the paragraphs and also hand over?
Wherefrom it would be evident that government has abandoned the project.
My lord, that in the
Document to show.
in the affidavit we have, my lord, in our opposition, we have stated, my lord, for the timing, government has abandoned. It may be that government may take up this project sometimes after, but not now.
Okay. That's all?
That's all. Because nothing extensive in the matter, my lord. And I have dealt, my lord, their allegations in
Of
every
a
paragraph.
tender process.
Lordship, would kindly allow us to file, make a reply, my lord, or my lord, to your lordship.
A cancellation of a tender process, which according to the petitioner is arbitrary. Next. অনেক
I beg to appeal for the respondent number 5, madam.
এটা এতক্ষণ 2 হলো ও বাবা Yes.
I am for respondent number 3 and 4. The ombudsman has rejected the claim of the petitioner, my lord. Kindly recall.
To release the insured amount to the petitioner within stipulated period death benefit by cancelling the award. Award means who
Page
passed the
59.
award? Huh?
Page 59.
58.
Insurance ombudsman has rejected the award, my lord.
11 page 6.
Suppression of medical.
I want to get this clarification whether there is no appellate authority provision for appeal.
No.
The petition is meant. The only judicial review.
Only judicial review, but my lord.
Huh?
Yes. अच्छा की झूठा नहीं.
There is no.
Okay, you tell the fact.
What happened, my lord? In the year 2018, the petitioner's wife purchased the master policy.
Purchase? Yes. Yes.
Page 17.
17. Yes.
May I read, my lord? Statement made in the form that the master policy order we are the liability as a member of the namely group class administered by the National Bank of India and the group credit protection class issued by Bajaj Insurance Company to United Bank of India bearing numbers 1. Proposed insurance, Mrs. Monica Monk, who is the wife of the petitioner. Membership number 2 and so. Date of commencement of this
Such and such, yes.
6 March 2018. Thereafter, what happened on 8 July 2020, the petitioner's wife died at the age of 29 years, leaving behind her minor son and husband. That death certificate is at page 15.
Page 15. Yes.
Name of this is Monica Vishwas Manju.
Yes, died. Yes.
Thereafter, the petitioner made application to the bank for settlement of her wife's claim.
Insurance claim, yes.
The state doctor along with supportive documents. The bank forwarded the document to the insurance company. That is at page 25 to 48. Copy of the letter and document.
Such and such relevant document produced to the insurer through the bank.
Through the bank.
Okay.
Thereafter, due to non-settlement of the claim, the petitioner made representation. The bank. Other than insurance.
Yes.
That is that page
49. Yes. Yes. Petitioner approached the ombudsman.
Insurance company deputized the claim of the name of the petitioner. Insurance company.
Insurance company, what? Yes. Repudiated the claim. Yes. Yes. Page 52. 52. Yes.
Made complaint to the authority that insurance company. Insurance compartment passed issued order that is at page 59.
59. Yes.
And it
Yes.
one policy was issued to the 6 March 20 or some on 8/7/2025. As on the date of the all of this as known as by the maximum doctor which have all system by the insurer on the ground of suppression of as per the same insurer clarified that the life was suffering contention of the content arranged at home March 20, when no history of any illness or any sort of complications were observed, and last time they came 17 July 2018 from MRI of brain from Apple Hospital. So they never suppressed anything in that. They happy officers. As per ACM, the insurer clarified that I suffered American brain tumor Memorial Day to something of section by 2007. Yes, sir. Yeah. So, was suffering from American brain tumor and subsequent expired on 8/7/2020 and what was by the doctor was then this is as per section 45 of the in view of the above, taking into account the facts and circumstances of the case, the submission related by both the parties and after doing some reports, it observed that the policy should not have been some proposal on submitted and did not disclose from the trade, which proves not disclosure of the material trade. Suppression as a and trade part of the finance as per section 45 of the insurance. So now this is the subject matter of share. First, I had no knowledge prior to 2018 before MRI that I was suffering in brain tumor or anything because I never admitted in any hospital. I never admitted. I had not been suffering any major ill or serious ill. Therefore, and not a single document provided to the petitioner that this is the prescription of yours. I have not suppressed anything. This is and only mentioned in the month of July. No date, nothing has been mentioned. Is it a order? Only in the month of July 2007. From when, if there is a prescription, there is a specific date.
Question of fact.
No, this is not a disputed question of fact. Only mention, only mere statement. Where is that document? Only direct my learned friend to file an affidavit in opposition. Otherwise, if the matter relates to go to the consumer court or civil court, it will take long time.
That cannot be done.
There is a judgment. There is a judgment, my lord. Yes, I shall show.
Now it's a dispute between the consumer and the service provider. Require evidence to be
Only
decided.
mere statement, I have made a statement that you have suffered on and from July 2017. Where is that document? Without documents,
has to be
if an order is part, that's
through evidence.
nullity in the eye of law.
Actually, in such question of fact,
Yes.
to ascertain which evidence is required,
Yes.
should be placed before the authority which takes evidence to decide any question. Maybe the consumer forum and
No, I have
writ petition is purely summary procedure one.
I have produced each and every document before the ombudsman, but the bank did not.
And one expert,
insurance company not produced any.
one
single
expert
document.
is to be appointed. That expert actually you are saying
Medical documents has to be-
suddenly in 2008 or 2018 or 17, you detected thereafter no symptoms was failed, nothing failed. Suddenly it was detected. Don't take it otherwise. Don't get hurt. Cancer second stage. Suddenly. Now it is expert opinions is required. Whether a person he will feel any symptoms or anything during long period, and in the particular case it may happen. A expert opinion is also required to be consulted.
It may happen, but it's not
This question is depends upon hangs upon the resolution of two other questions.
Only I am praying is produce a single document. There is no such a this is serious nature of disputed of fact. Only produce a medical certificate. Yes, I am suffering from 2017. Then I have no case. Kindly
You approach the consumer forum also,
Kindly direct
and Mr. Saha, court will observe that this order as well as the award will not stand in the way.
Yes.
Huh?
That has been the consistent.
The effect of the award is also nullified, so that it cannot act as a res judicator.
Yes.
Cannot operate as a res judicator. I can, this court can do at best for.
The petition is maintainable. I shall show a judgment, my lord, similar type of matter.
Oh, no. Okay. So,
Reference to only.
Life Insurance Corporation of India and others versus Asha Kore.
Yes.
That is 2001 to Supreme Court cases 160.
Asha Kadam.
Asha Kore.
Asha.
May I read you not?
It is well settled principle.
Yes. Here also.
Yes, got it.
Are also contention of the.
It cannot be stated that insurance policy can never be enforced under Article 226. But if to enforce it, if it is felt that some question of fact is to be resolved, and for such resolution evidence is required, then actually court will go. Even where question of fact is involved, court will go. Up to that point, where evidence is not required.
What is required?
Where the question of fact only on the paper,
only
court can go.
Yes, it is only on the papers.
My respectful view,
Understanding.
court can go.
Yes.
When it will find that no, this fact is to be ascertained by evidence, then it restrain itself from proceeding further.
What is required here?
This
Only they
case
are
is required the expert opinion. Otherwise, it cannot be decided.
As per order, can you see the order again? I am reading the award.
Mr. Shah, go to, don't waste time.
No, I am.
It is his case that he is denying the investigation report.
Yes.
If that is the issue, that is purely a disputed questions of fact.
Report?
Investigation report has been placed.
Application of the insurance company that she is suffering from 2017.
Cannot be turned out.
She is suffering from 2017, but not a single document annex. Only one prescription is required. kindly direct them to produce the prescription.
Prescription where they will, it is your document.
I have already.
You are the custody, you should,
Yes, I
you
have
should
already-
be the,
No.
your custody is the proper custody of your prescription.
I have no prescription.
My prescription,
Yes, yes.
custodian myself.
It is your custody. Yes, my lord. That is absolutely true.
I am the custodian of my prescription. Who is-
Prior to 2018, I have no prescription. Prior to 2018, kindly dear, consider the same. Prior to, I have categorically stated that prior to 2018, I have no prescription of brain tumor, etc. Because I had never fallen any serious type of ill. The petitioner was an assistant teacher of a school. She discharged her
Appropriate forum,
duty.
consumer forum.
She discharged her duty.
Mr. Saha, it would be proper. I at best, for you, I can say, I shall nullify the effect of the award so that the award cannot operate as a res judicator. And court will observe that this order as well as the order, excuse my reputation, this order and the award will not operate as a res judicator, and will not stand in the way.
My lord, in any case, that is written in the award.
Here evidence is required.
Yes.
And one doctor's opinion, in case maybe so one doctor's opinion is also required. And a writ court cannot ask the one doctor or expert come on my dock and depose.
No. If doctor's opinion is required, if they mention in the order that prior to 9 years or 10 years back,
They have not.
No, that is not the contention of the insurance company.
The court.
What is the contention of the insurance company? She is suffering in the month of July 2017. Where is that document? Because I have no document. I am the custodian of the prescription, but I have no documents. As because I had admitted in the 2018.
Okay.
And paragraph 10 and 11 of the Ashakal judgment clearly stated that this court has a extraordinary jurisdiction and has a power. My lord, kindly see the order.
My lord, will allow me to submit on the issue of law with respect to the powers of ombudsman. My lord, kindly seize the ombudsman books. This is created under the PRDA Act. Kindly seize section 13, subsection 2.
Yes.
What is the nature of proceedings which is happening before the ombudsman? He is only a mediator. He is doing mediation. And if the mediation fails, judicial review is not the recourse. There is an appropriate forum. My learned friend is trying to enforce a private contract through writ petitions. Already the award clearly says that if you do not agree to it, the appropriate forum is the consumer forum.
Exceptional circumstance.
And there is a clear act.
It is Bajaj.
Bajaj.
I have a private insurance. In that also private.
Private.
Okay, I am
by following the Ashakal
in invocation of extraordinary jurisdiction of this court. The
A liquor license under 4Q of legal action. The 4Q was not in the act subsequent to the year number. Art of October 2018, this 4Q was.
Who is your other side?
My lord,
Liquor shop license. It has been cancelled.
my lord, liquor shop license temporary license given subsequently that permission of 4Q has been withheld. That is removed because given in effect by my lord investigation 4Q. Art of October 2018.
Oh, earlier or
For the earlier one, my lord, that's Raja Silver Mountain, my lord, there is a.
okay, let the state come. Okay. अच्छा ये appear ये. Despite service, have you served? Despite service, state is unrepresented. Yes, cancel withdraw the appointment and license issued in favor of the MRR. Oh, marriage, same Murari part B now.
That was taken up last Monday. You also directed me to give a notice to all these parties.
Oh, yeah, notice coming. All are present. All are present.
Yeah, never.
Who is for the state?
My lord, Mr. Galib is appearing for the state, led by Mr. Galib.
Yeah.
Affidavit of opposition direction was there, my lord.
Huh?
Affidavit in opposition direction was there, my lord.
Affidavit has been filed.
Why respondent number state has not filed, my lord?
Only affidavit service. No affidavit is there.
Direction was there.
Reply.
Affidavit in opposition has been given.
Oh, you are for the
Petitioner.
petitioner. Oh, so you have given copy of the affidavit in opposition.
My lord, I am for the private respondent. I serve the affidavit in opposition.
Oh, private respondent.
Private respondent. My lord, difficulty is that respondent number 1 is judicial department. My lord, now his matter is looked after by law department. So
Let me make my submission. I open my case.
Yes.
Some amendment is required, my lord, first item.
My lord,
the judicial department made party, my lord, but law department is taking this matter for necessary action. My lord.
Whether judicial secretary or law secretary is different.
Yes.
Different. That's what is different.
Now, my lord, what happened, I tell Rossi. But don't open this brief. Kindly hear with me. Now, the petitioner challenged the appointment of a private respondent on the twofold ground. First ground, he is overaged, where the Gazette notification provides regarding the appointment of a Muslim marriage registrar, the age will be in between 25 to 40. I have annexed this notification. And the second ground there, while he was appointed as a MMR in respect of the Morarai B police station, now he was a Samporosaro in the another, my lord, Gram Panchayat, and he is drawing salary. Now, my lord, section 24 of the rules provides, Now, if you want to be a salaried person in some other project, you have to take a permission from the IGR, Inspector General Registration. This is my twofold ground. Now, in respect of the Murarai Part B police station, kindly see in my writ petitions. Kindly see page 29 first.
Yes.
The notification, kindly see this date. 6 January, notification page 29.
29, I am on 29.
Date, my kindly see 18
May
2018.
2018, yes.
Now kindly see Murarai Part A, Murarai Part B.
Yes.
Comprising the, I am concerned with the Murarai Part B. Comprising the territorial limits, Murarai Block 2, falling within the Murarai PS. Number, I made an application in respect of that Murarai police station. That is my lord, page 23. No, page 27. Sorry, page 27. As you also got it.
27, yes.
Kindly see this date, 28 July 2018. After the notification.
Yes.
18 May notification. 20th July 2018 notification. I made an application. Now, my lord, subsequently, I made an application before the authority relating to the date of birth of the private respondent. Now, kindly see page 30.
Yes.
Kindly see Muhammad Allah Rakhamia, who is the private respondent herein. What is the date of birth? 6 January 1965. He has been appointed in 2018 at the age of 54 years. I will show this appointment. His appointment. 6 January 1965. Now, my lord, what is the qualification? Date of joining. Kindly see 25th June, September 2006. As a Samprasarok, monthly salary honorarium 8930. Lordship got it. This appointment has been done in 2006. Joining. Here, he has been appointed in 2018. That is as MMR. Now, kindly see the next page. Page 32.
Yes.
I made also an application. The letter was issued to the petitioner Abdul Goni. Now, the approval, the above mentioned subject, the undersigned is sending the reply of the RTI as per available. Muhammad Allah Kamia is not a teacher of Chaitanya ASK. He is a Sikha Sampasarok of Chaitanya ASK. Admitted fact. Date of birth 6 January 1965. Admitted fact. But this is the situation. Now, kindly see, I have annexed the notification. Now, page 23.
Yes.
Number 4. This is the Gazette notification. Calcutta University. Point number 4. In case of a permanent appointment, the candidate shall not be less than 25 years and not more than 40 years on the date of inviting application at sub-rule A, rule 3. Therefore, the age limit 25 to 40. Now, kindly see, in their affidavit in opposition, page 19.
Where is the opposition? It is reply. Where is the opposition? Have you submitted the opposition in court? Where is your opposition? The petition and affidavit in reply. I want affidavit of service. Nothing.
I have been served in opposition.
Have you submitted in court? Where is the copy which you affirm? Get it affirm.
Yes, my lord, but I could not remember that whether it is. But I'm on 2nd February 2023.
You are not concerned or interested.
But I am giving that copy.
Day of February.
Which yes, sir.
Huh?
2nd February 2023, my lord.
So give your copy. Yes,
Page 19 of their affidavit in opposition.
page 19. Yes,
And you will also remember the notification, the bifurcation of the Murarai has been published in 18th May 2018. Lordship, remember, I have shown you, Lordship. Now kindly see the appointment letter. 18 May 2018. Kindly see the appointment. This is the appointment letter. I am referring this. Page 19. And this is, I have shown to your Lordship, the Murarai bifurcated, page now 29. Kindly see the date.
same date.
Same date. Kindly visualize this. Now what happened in that day? On that day, immediately appointment has been given. Without publishing any notification, nobody will know. Immediately the appointment has been given. Kindly see the, I am reading that. 18 May 2018, paragraph 2. I am to say further that after the consent of the prayer dated 15 February 2018, Muhammad Aldara Kamia, prayer dated successor of Abibur Rahman Siraji, Imam and Kaji, the report placed by the DR Bibu and on perusal of the relevant office records, the state government has accorded approval for appointment of the Aldara Kamia, Nabib Kaji Abibur Rahman, in village post Chaitanya, PS Purari, district Birbhum as temporary MMR, comprising the territorial limit Murarai Block 2 within the Murarai PL, district Birbhum as a special case. Now next para. In view of the above, I am to request you to take steps for appointment of Muhammad Aldara Kamia as temporary MMR of Murarai Part B, MMR office comprising the territorial limits of Murarai Block 2 within Murarai PL, district Birbhum under Rule 3B of the Bengal Mohammedan Marriage and Divorce Registration Rules 1929. Next para. I am to request you to take steps for filling up the post of Murarai Part A, MMR after comprising territorial limits of Murarai 1 block in the district Birbhum in the recruitment process of, kindly see, in the recruitment process, the application of Muhammad Abdul Goni, the petitioner before your lordship, the petitioner in 541 and another application, if any, should duly be considered in terms of the MMR Rule 1929 and the panel may be sent to the department. Now, this appointment was given in 2018 when the bifurcation was done. Without making any application, without giving any opportunity to other applicant who has got the requisite criteria. Straight away, the appointment letter. Even he is aged about at that material point.
What is the procedure to be followed to give this such appointment?
I am giving that. I am giving that. What is the procedure? Now, thereafter, straight away the appointment has been given. And kindly see, in their affidavit, they have stated that the relaxation has been given to their age. Relaxation has been given. Now, kindly see the relaxation documents, page 15.
Of your writ petition?
No, their affidavit.
Oh. Yes.
Before showing that, I will show the rules first of all. What is the rules? So far the temporary appointment is concerned, Rule 3B deals with. Rule 3B. What is the Rule 3B? I am showing to your lordship. Rule 3B. Procedure in making the temporary appointment. In making temporary appointment, the permanent, B, rule, the permanent committee is not consulted. The district registrar shall nominate a suitable person for each vacancy. The district registrar's nomination shall be submitted to the government by the Inspector General of Registration, who, if he disapproves the district registrar's nominee, may recommend the appointment of another candidate and a temporary license shall be given. This is the procedure. First of all, the application has to be made before the district registrar. District registrar shall send this nominee to the IGR. IGR, if it approved it, can send directly to the government to approval, or if it disapproved it, then he can send another person. This is the procedure. Now, here in this case, There is no procedure adopted as per Rule 3B. The procedure was directly given the appointment in favor of the petitioner when the private respondent when the bifurcation has been done. Now kindly see Rule 4B.
Where is the rule? It is with you.
I am giving that.
Not
Kindly
with
see,
me.
kindly see this. Rule 3B and Rule 4B. I'm giving
3B and 4. Oh, yeah. You have no copy. So you read first.
I have the copy. I have the copy.
3B.
Rule 4B.
Who's your option?
I should got it. Notwithstanding anything contained in Rule 4, the state government may, for any special reason to be recorded in writing, by order, relax the minimum age of upper limit of a candidate for being appointed as a temporary Mohammedan registrar.
You are reading from?
Rule 4B.
41. Oh. Yes, 4B.
Power to relax the rules. Now, my lord, notwithstanding anything contained in Rule 4, the state government may, for any special reason, to be recorded in writing, by order, relax the minimum age of upper age limit. When I am emphasizing this word,
For
state government
any
may,
special-
for any special reason,
To be
recorded in writing. Age limit of a candidate for being appointed as a temporary Mohammedan registrar, or in case of appointment of Mohammedan registrar on conventional ground. Therefore, the region has to be recorded in writing. For what region, but what purpose we have relaxed this age? These are the contention of the legislature. Now, my lord, what the order was passed by the relaxation of the age by the government, page 15 in their affidavit.
To the affidavit.
Yes.
My lord,
Yes, 15.
in exercise of the power conferred by Rule B, 4B of the Bengal Mohammedan Marriage and Divorce Registration Rules 1929, as amended by the notification that is 6 January 2000, published in ordinary extraordinary issue and Kolkata Gazette. The governor is pleased hereby to relax the upper age limit of Muhammad Allah Kamia, age 53, son of such and such, for the purpose of appointing him as a temporary Mohammedan marriage registrar of Murarai B, a member office comprising the territorial area of Murarai Block 2, falling within the Murarai PS area in the district Birbhum, in place of Habibur Rahman. Therefore, no region has been mentioned. No specific has been mentioned. Only relaxation has been given for giving appointment of Allah Kamia in Murarai Part B police station. Rule provides or postulates that you have to specify the region in writing. For what purpose you have relaxed this age? But this is not being reflected from this impugned order. This is my first. The second point is that he is working as a Samprasarok. In 2006 he has joined. Now, 2018 he has joined in the MMR. Now can the Rule 24.
Yes.
Can you see these rules? Therefore, he has to take the permission from the IGR. Now, last column, kindly see. Any Mohammedan minister shall not be divorced from holding any other salaried employment, provided that it does not interfere with the proper discharge of his duty.
Okay, I have got your point.
Hello?
I have got your
I have some last. I will put certain judgment. I will put certain judgment.
Oh, judgment. Yes.
Before, my lord, before going into the acts and rules of the appointment of Mohammedan marriage registrar, my respectful submissions are 2 in number. One, my lord, he is a gentleman who filed a writ petition in the year 2017.
2017.
2017. Got it dismissed for default. Filed this sheet in the year 2022. Kindly cease from the length and breadth of this writ petition whether he has been disclosed regarding that particular issue or not. Yes, I am Lord, settled proposition. Lordship also, I learned from your Lordship, Order 9. Dismiss or default does not prevent from filing a new application. But suppression cannot be condoned. Kindly cease whether he has disclosed this or not, Lordship. If that be so, my Lord, it is settled proposition on the ground of suppression itself. The court cannot enter into the merit of the case. At least I have gone through the writ petition. He has
No, I'm not highlighted.
disclosed.
I'm giving it.
So on that ground itself,
What is the number of that?
my Lord, WPA, my
And
Lord,
what is the dismissal date? WP
5410
5410.
within bracket WR 2017.
Yes. Dismiss for default when?
Dismiss for default 3rd July 2017.
3rd July 2017.
Okay.
Any disclosure on this?
I'm giving that.
Okay.
I'm giving.
No, I'll have to show from the pleading that he has disclosed this.
I have not pleaded. Why I am not pleaded? That's I'm giving the reply.
No. Of the self-same cause of action.
I'm giving the reply.
In the pleading, it has to be there, whether it is disclosed or not.
It has not been pleaded.
Then on that and that point itself, it has to be dismissed. Because
Court will.
my Lord, I'll have to place the judgment on that. Suppression, if there is a suppression, my Lord, then court will not go into the question of merit of the grievance. Suppression itself is enough. Suppression itself is.
Okay. You have raised this point. Now allow the court to deal with this point. Or to give answer to this.
My Lord, I'll have to place that judgment. Today I have not come with.
You have completed your
No, I'm
submission.
giving that reply. Why I am not pleaded that?
It is a motion, so much time. Okay.
Because when I tell you, see, when the Murarai station was not bifurcated, in 2016, I make an application. For that purpose, for consideration, I came here. In 2018, when it was bifurcated, part A, part B, I made an application in 2018 for part B. This is separate cause of action, fresh cause of action. This is a fresh cause of action. Therefore, in 2016, when I make an application, that is automatically impactual by virtue of the bifurcation of Murarai part A, part B. And when the bifurcation has been done, again I made an application in Murarai part B in 2018. Therefore, this is not the question to deal with.
Yes. Now, what is judgment?
Yes. This point relating to the overage was, my Lord, came up before the Honorable Coordinate Bench. The Honorable Coordinate Bench passed an order. Thanks.
Yes, where is the proposal?
Paragraph 20, can you see? Paragraph 20.
Paragraph
20. 20.
20, yes.
That's wrong, forgot it. However, the facts of the present repetition are different. A distributed year is the relaxation of the age of the pipe of court without recording any special regime as contemplated in clause 4B of the relevant notification. Without which the question of bypassing the petitioner for the post would not arise. Now, can you see next paragraph 23?
Yes.
In the present case, the post facto justification, here the approval was given without recording any reason under 4B. In the present case, the post facto justification given by way of a report of the Joint Secretary, Law Department, dated 4th January 2021, handed over this court on behalf of the state, the insufficient compliance with section 4B of the notification dated 14th August 1929. The explanation given therein was never reflected in the impugned order of appointment of the Responsible number 4 as a temporary MMR Next, paragraph 24. A decision under clause 4B of the notification has to be visited by a special region to be given in writing, which is absent in the present case. Therefore, in that view of the method, his appointment was cancelled by the coordinate bench. Now, the second summation is that when there is an in contravention, because he has got no requisite qualification, so far the age is concerned. He was at the age of 53 years got this appointment. Therefore, he has got no requisite eligibility criteria for getting this appointment. Now, your lordship knows the Supreme Court has stated the judgment. And kindly see.
Yes.
On paragraph 9.
Yes.
In view of the foregoing decision, we have no option but to hold that if any appointment is made in fraction of the recruitment rules, the same would be violative of Article 14 of the Constitution of India, and being a nullity would be liable to be concealed. This is the proposition. Therefore, if the appointment is being made in violation of the rule, you cannot claim any equity regarding the service of the continuation service. If the appointment is illegal, this appointment cannot be tenable. This appointment is liable to be set aside. The same view has been adopted in another judgment of the
How? Yes, yes. Yes, paragraph.
I have given the red mark. But I can say this judgment.
আমাকে use
We
করতে
judgment
হবে affidavit।
for the watchman.
কোনটা? Yes. Paragraph.
Paragraph, I'm giving the paragraph. Paragraph 27, 28. Same view was adopted. If somebody lacks his qualification in getting this appointment, his appointment will go. All the qualification and age criteria is within the purview of the eligibility criteria.
Okay.
Therefore, this appointment cannot be tenable and is liable to be set aside.
Okay.
My lord, I was willing to make the second submission. That was my first submission. My second submission will be the respondent one. My learned friend has implicated judicial department. My lord, since 2018, my lord, the list of business of marriage matter has been shifted to the law department. So if my learned friend will correct this particular cost item, my lord, I can get an opposition done by the law department on this issue, my lord, fortnight's time. And my third, my lord, responsible submission is kindly keep the mental limit open. Because judicial department is the party respondent. Now, since 20, I don't know, my learned friend usually appears in MMR matter. It's a matter of 2022. So 2018, the matter has been changed, marriage matters has been shifted from judicial department to law department. So I'll have to get the
one department from of the state to another department of the state. Now I am asking him to make party. So whether you have not taken instruction from law department,
I'm not on instruction.
it has been changed due to your cause, due to your convenience to run the administrator.
No, my lord, but if the wrong respondent has been implicated in my lord,
Who passed the order? Secretary? Who passed the secretary, government of West Bengal Judicial Department, Writers Building?
that was, my lord.
That order is under challenge.
Yes.
When you are changing the same
List of business, my lord, the list of business was changed by notification dated 6th December 2018.
So why?
But the order under judicial challenge.
The order passed on the judicial department.
You know, all are under the government of West Bengal. It's a department of 2018 6th December. the list of business has come to the Milord, the law
He has
department.
challenged
My
the
learned
order.
friend is filing 2022 writ petition in the year 2020. Now they are in season of the entire record, not the judicial. Now, if I chase the judicial department, please give me the opposition. They will say our record has gone to law department. So kindly, Milord, understand our predicament, Milord. Everything under government of West Bengal, no doubt. But because department to department, I shall. I never retreat from facing the case.
And they have no
I will give you an answer to all these. I will give answer to all these.
Matter is final hearing. Now he is taking that plea. He did not file an affidavit. He did not plead that point. Take that point at the time of initial.
Then okay, let it be decided. Let it be decided. Okay, since my learned friend wants it to be decided, you decide. Lordship, kindly decide, Lordship. He is not willing to face the challenge from me. That's why he's doing all this. He's not going to face the challenge from me. That's why he's doing this. At least had I been in his position, I would not indulge the court, my lord, that yes, when my learned friend is willing to go for apposition,
It is your lacuna.
he has implemented wrong respondent. I am facilitating.
Why wrong?
Order, who passed the order?
Milord 2022, Milord,
Who passed the order?
Milord, may I show from his representation at page 28? Kindly see the representation at page 28 of the petition. Who is the addressee? He himself has corrected this. His representation at page 28 of the writ petition dated 30th January 2022. Who is he addressing? Who is he addressing? Huh? Judicial Secretary. So is it my correction?
Why you are shouting?
I couldn't understand. He did not make any plea at the time of motion stay. He did not file any affidavit. Now he is taking the plea at the final hearing stage. That law department will make a party.
He himself made a representation before the law department on 30th January 2022.
So when the
his affirmation is on.
You see that?
His affirmation is on 9 September 2022, the writ petition. Then also he is making a judicial department a party respondent.
Judicial secretary is under challenge.
So I am informing the court that there is a change of department.
Judicially or judicial secretary order is under challenge. If you lost him quash this order, what order will be quashed? Judicial secretary order, not the law department order.
All documents by the judicial secretary.
All the documents.
18 all documents. 27 judicial secretary. If there is a change of business in the interdepartmental transfer of business, unless the subsequent department is not made party, the advocate will not get any instruction or court will not be able to dispose of the matter. Court is to wait, taking cognizance of subsequent change of business in the
kindly see
department.
Page 20 of the opposition, my learned friend has filed. It's a document of law department. Milord, I am apprising the court, Milord.
Okay. Only point the state. The state stand only this point. 2 point not maintainable and that there is a change of business. Only this 2 point.
So, Milord, on this point, Milord, I am praying for, Milord, leave to file opposition upon implement of Milord, law department.
Leave was granted to you, but you have not availed of that opportunity. It is not that going on granting indefinite period. When the direction was given to file affidavit in opposition?
January, Milord, 2023.
January 2023.
Yeah.
Court is bound to accept your affidavit or bound to grant leave. Show us any authority, show us that As and when state will ask, court will remain bound to give such a extension. Since they are raising voice in so the court is bound. Record and order. During the hearing, Mr. Galib entered 16 70.
And I have appeared for
89 after 70. 89. Yes. What is the show urgency?
my lord, I appear for the petition.
89 lines.
Subject to correction, my lord, that just now I have received this notice that it has been fixed at 2 p.m. But this matter, my lord,
What you said?
now the
there is
clerk
a-
has
my lord,
informed
there-
You had a talk with
my lord,
Mr.
my lord,
Dev.
through email, my lord, it was
through mail, my lord,
there is
who
an
checks the
urgency,
email,
my lord,
my
which
lord.
has prompted me to mention before, my lord,
And
the date of my lord, for granting recognition, my
Come
lord,
tomorrow, he is without brief
is
today.
expiring.
Without brief, and
Tomorrow
another
is the
thing,
last date, my lord, for granting recognition and admission, my lord,
My lord,
for running
another
the
thing,
D
my lord.
Pharma course, my lord.
My lord, another thing. This is a, my lord, subject to correction. It is, my lord, in the motion stage, I presume. My lord.
My lord, there was a direction for filing report and
Report.
exception.
Yes, sir, there
That's
it
why
is a
perhaps
report,
it has.
motion stage. Although, my lord, it is a great opportunity for all of the junior advocates to, my lord, to appraise your lordship. But it is subject to correction that it is not in the hearing stage.
It's a
It's a
motion
report.
matter.
Whether if my lord pleases to, my lord,
But
tomorrow.
there is a direction for filing report and exception, my lord. It was admitted, my lord. Therefore, my lord, it is a hearing matter, my lord. It petition has already been admitted.
Not a formal affidavit in opposition, then we have to.
These are technical points, my lord.
Not technical. This if we
Whoever
are
it-
pleases to appear, but when next week, my lord,
But tomorrow is the last date for granting recognition. Otherwise, I would not have disturbed your lordship, my
that
lord.
they will be, they have any inherent right or not, that are only a subject
My
to,
lord,
my
we
lord.
have, my lord, we have prayed for affiliation before the council, my lord. On the basis of that, my lord, hearing was conducted. No decision has been, my lord, communicated. My lord, during the course of hearing, my lord, I was asked, my lord, to submit, my lord, the building completion certificate that I have submitted, my lord. And also, my lord, there were certain, my lord, the deficiencies in my college, my lord, that has been meet up, my lord. My lord, only the council may be directed to make a further fresh inspection and to take a decision on the basis of my application for affiliation. Only this order, my lord. Only
In
this
this,
order,
my lord,
fresh inspection or, my lord, and on the basis of that, my lord, since
the
we have, my lord,
recognition-
we have already meet up the deficiency which has been
If it is your prayer,
it is a
in
time,
these
it is a
circumstances, there
time
is no
bound manner.
requirement to take up before 8 or
yes, my lord. Thereafter, my lord,
any day can be taken.
no, my lord, thereafter, my lord, we shall pray for, my lord, the recognition and admission, my lord.
My lord, that is already over.
No,
Subject to correction, that
my
is the
lord,
May.
there are
We are
decisions
not
of
going
this
on for
honorable
any.
There are decision of this honorable court that where the affiliation has been granted, but it can be extended.
No,
Size the
no,
date
no.
of recognition and admission.
No, no, I completely, my lord,
Okay, so tomorrow can be taken up.
tomorrow, my lord, it will be, my lord, for me, my lord, Tuesday, because
very short matter.
I am not, I
What matter I know.
that I have
Only
to,
one of the
I have to
direction for fresh
know.
inspection and take
How-
it.
take
how I
instruction
can-
from the department. It is not the petitioner. I will, my lord, come with prepared. Tuesday I shall be. Tuesday I shall be come with instruction. কালকে হবে না ভাই, আমি আমার সাথে কথা বলে জানাতে হবে what is the present situation. They are saying that there's a recognition that is all over in January. It is not in the month of May. This is a time bound manner.
My lord, it is not in the March, my lord.
So tomorrow come tomorrow.
My lord, my lord, get me.
এটা কালকে ওই একদম
mention.
ওপরে দিয়ে দেবেন।
Get me. Get me.
Tomorrow, Mr. Dev.
Tomorrow then 2 p.m. My lord, they'll, I will to inform their officers. They will, my lord, come with the, if certain name, again I have to, my lord, pray for accommodation at least 2 p.m.
2 p.m. my lord, 2 p.m.
2 p.m. Okay. Tomorrow 2 p.m.
2 p.m.
Tomorrow.
Get service.
So let তুমি চ্যান্সেলর একটা অর্ডার
হ্যাঁ, one line judicial.
সোমন বাবু একটা অর্ডার করে দিন the hearing of this petition taken up out of turn at the instance of the এটা দিয়ে দিন তো
My lord, this 90, 89 and 90 minute analogous both the matter. তাই না? 89 and 90. But I am participating 90.
89 Lordship, Mr. Agnik Chatterjee is appearing for the state. He has to leave the court for some personal difficulties. Lordship, praying for an adjournment.
No.
Lordship,
This matter was fixed long time. I can.
Lordship, he has a personal difficulty for which he has to instantly leave for the home.
Let the other matter be taken up. Both the matters are analogous. If one.
No, my lord, it's better to take up both the matter because it's related with each other.
This is the only ploy
If one matter is adjourned,
employed by everyone so as to prevent. Let me commence my hearing. The matter will not be over.
Lordship, the state advocate
He is
is
there. Let him be there. I am strictly opposing the prayer. I am very sorry, but
Lordship, kindly grant an adjournment for the day because the advocate has to leave for the personal difficulty.
If your lordship hears the matter for 2 minutes, then your lordship will kindly, bear with me. The first matter.
Yes.
Please take WPA people
WPA 11880.
Lordship, kindly, if Lordship.
Okay, no order will be passed. Adverse order will be passed without hearing the submission.
Lordship.
You keep patience. Yes.
Had he given any impression, then we wouldn't have asked people to come all the way from Bethua Dowry to attend the hearing. He should have given this impression that he's going to pray for an adjournment.
Lordship, this has arisen just a few moments before. He has to rush home for some personal difficulties, Lordship. That's why he has informed me to inform the court, Lordship. It was not beforehand that he knew that this thing would happen.
Mr. Boisho is leading him. Let Mr. Boisho come.
Mr. Shagnik Chatterjee has informed me this.
Mr. Boisho is the learned additional government Peter. He is leading him.
I'm not
He knows.
aware of.
Mr. Shagnik Chatterjee is
Mr. Chatterjee.
Mr. Chatterjee.
Mr. Chatterjee means who is Chatterjee?
Shagnik Chatterjee.
The state,
Yes, Lordship. He is for the state, Lord.
Oh, regarding release of retirement benefits.
Yes, yes.
Including pension, commuted value of pension, gratuity, provident fund. So why it has been withheld?
The criminal case is pending.
Huh?
No. The criminal case is pending means criminal case will remain pending in the year 2030 also. Because there is no endeavor by anyone to conclude the criminal case. And by citing pendency of the criminal case, I am being deprived from my legitimate benefits.
His read application relates to release of pension. The court observed that until and unless the criminal case is disposed of, you cannot.
That is contrary to law.
You are entitled only.
We are at the final hearing stage. Let me.
This court observed it.
Yes, that he is entitled. Presently, he is entitled only the family provisional pension that has been started. And he is getting family pension, provisional pension.
There is no scope of passing interim order. The court observed.
Yes.
Okay, what Mr. Boyd submits. Court observation considering this submission and rival contention of the parties. There is no scope of passing interim order, then invited affidavit. It is made clear in the meantime and during pendency of this petition, respondent number others shall go on paying provisional pension to the petitioner strictly in accordance with law. Now, question is, Mr. Bari, whether if there is no allegation of your financial loss suffered by the employer following any act or inaction or omission on the part of the petitioner, whether it would be justified to withhold the entire.
Very serious allegation. I will demonstrate. Let him. I will demonstrate.
Okay.
What little that we know from my learned friends, any proceeding legally is deemed to be pending, provided there is any charge sheet which is filed. In the departmental matter, there is no charge sheet. As on date, there is no charge sheet. Never initiated. There is no departmental proceeding.
Yes.
The person has been permitted to proceed on retirement. He was getting some amount towards subsistence allowance. He was placed under suspension. He carried 2 proceedings. before your lordship's honorable court. One in the original side, one in the appellate side. Both the writ petitions come up for consideration before a coordinate bench of your lordship's court. Ultimately, both the writ petitions decided either way. What is the decision? He was covered by the 1972 sponsored rules. 1972, when he was placed under suspension. In the 2018 rules, provision is there for payment of subsistence allowance. Your lordship's court held that insofar as subsistence allowance is concerned, from the date of suspension till promulgation of the 2018 rules, he be paid the entirety of the salary because there is no provision in the rules for withholding salary. I assure my learned friend nothing is against the state. It's by this between the school and myself. Please inform Mr. Boisho. He is appearing for the state as Mr. Chatterjee's leader.
I have been informed by Mr. Chatterjee, that's why I am
Anyways,
not aware of it.
Thing is, this teacher was placed under suspension. The coordinate bench, as I told you, from that portion of the order, an appeal is carried. Which portion of the order? That he be paid his entirety of the benefits. This honorable court merely admits the appeal and there is no further direction. There is no endeavor taken by anyone to get the appeal listed. So the position is, I continue to remain under suspension. This honorable court also intended by way of the same order that proceedings, if not initiated, be initiated within a certain time frame. Has to be completed, not initiated, but completed. I am grateful to my learned friend. Now, that not done. Till date not done.
Any default clause was there?
Nothing.
No, any default clause was there in that order?
The clause is there. If in the event it is not completed, the consequence will follow. Now, they only say that there are criminal cases against you. The nature of criminal cases as on date is like, dates are framed, dates are, your lordship knows better than, 1 year, 1.5 years, 8 months, 9 months, these are the dates. Whenever the matter is, the prosecution is unable to proceed an inch, charge is not framed, nothing is done. And the matter is going on. Like this, every other day the matter is coming up and again it's getting adjourned. 2 criminal cases. In both the cases, this is the scenario. Now, in this backdrop, I came to your lordship's court in 2023 saying that, bhai, I have already demitted office on attaining the age of superannuation. So something has to be done regarding my entitlements. Ultimately, after a lot of persuasion, huge endeavor was made by a coordinate bench of your lordship's court. Your lordship will see the orders. Ultimately, both ways came to certain
terms,
agreement or terms to the extent that my provident fund, whatever little that has accrued, albeit without the corresponding fixations, because I was under suspension, my provident fund be released. Now, to the extent of gratuity, the Payment of Gratuity Act clearly says only gratuity can be withheld provided there is a conviction, not pendency. Not pendency. And Supreme Court has also interpreted it to be so. Pendency of a criminal case does not obviate my chances of receiving gratuity. If the criminal case continues still, assuming I am today 65 plus or 63 plus, today if it continues for eternity, then in the absence of any conviction, I will be deprived from my legitimate gratuity. Another aspect is my pension. Law says, the DCRB scheme says, I shall show your lordship one by one. The DCRB scheme says that in the event of some pendency, nothing. Only if a person is found guilty in a departmental or criminal proceeding, So guilty presupposes that there is a punishment. Then only the question of provident fund, then only the question of provisional pension subject to correction arises. Now, it is my bread and butter. When this order was made on 17th of May 2023 by a coordinate bench of your Lordship's court, my lord, I was on the verge of starvation. Today, I am getting an amount of merely 14,000 as against the fact that had all my benefits been extended to me, even provisional pension would have been 3 times. Even provisional pension would have been 3 times. So today, your Lordship may say that why are you opposing a prayer for adjournment? Now, this matter was previously taken up. I mentioned the matter when your Lordship was sitting singly, only to inform your Lordship that my provisional pension for 3 months was not paid. The moment I mentioned, the next day, within 2-3 days, they released it in my favor. The matter was adjourned. On one particular occasion, Mr. Chatterjee had met with an accident. I did not say anything. On the next day, he appeared to Mr. Boishu. And, my lord, the matter was heard by your Lordship, and the matter was fixed today. Now, therefore, my lord, in the conspectus of these facts, I will invite your Lordship first to the coordinate bench's order.
Justice Roy's order.
No, Justice Arijit Banerjee's order. Now, page 74 it begins. 74.
Yes.
Now, please come to page 78 straightway.
Yes.
My lord, the short question that arises for determination is whether or not the suspension order passed by the school authorities is valid in law. It is not in dispute that the 1972 rules governed the respondent school and not the 1969 rules, since on the date of issuance of the suspension order, the respondent school was a government-sponsored school. Rule 23 of the 1972 rules empowers the committee to remove or dismiss teachers and other employees. This rule fell for consideration in such and such. Hence, the committee of paragraph 15 of the had the power to issue the suspension order under the 1972 rules, and this point is no more res integra. The only other question is as to what payment the petitioner was or is entitled to during the period of suspension. Learned counsel for the respondent submitted that this point cannot be gone into by the court since the same is beyond the scope of the writ petition. There is no prayer in the writ petition regarding subsistence allowance during the period of suspension. I am unable to agree with the learned counsel for the respondent school. The issue of subsistence allowance is inextricably intertwined with the issue of suspension. Hence, I am of the view the court may well go into the said question. Further, the petitioner has prayed for release of his monthly salary month by month after quashing the suspension order. However, since I have found the suspension order to be valid, no question of quashing the same arises, and I deem it appropriate to express my opinion on the quantum of payment of that the petitioner is entitled to during the period of suspension. The 1972 rules do not have any provision regarding subsistence allowance, as has been held by the apex court in the case of such and such. If there is no express term in the employment contract relating to suspension and payment during such suspension, or if there is no statutory provision in law or rule, the employee is entitled to his full remuneration for the period of suspension. On the other hand, if there is a term in that regard in the employment contract, or there is a provision in the concerned statute or the rules framed thereunder providing for scale of payment during the suspension of payment, during suspension, the payment would be in accordance therewith. In the present case, there does not appear to be any term regarding subsistence allowance payable during the period of suspension in the contract of employment, nor any statutory rule has been drawn to my attention providing for payment of subsistence allowance during the period an employee remains under suspension by reason of issuance of a suspension order under the 1972 rules. Hence, in my opinion, the petitioner shall be entitled to payment of full remuneration from the period of his suspension till the date when the 2018 rules came into force. It is not in dispute that the 2000 rule applies to the respondent school. The said rules have specific provision pertaining to suspension and subsistence allowance during suspension. Hence, from the date 2018 rules come into effect, the petitioner will be entitled to subsistence allowance with rules in accordance with Rule 7. The challenge to the suspension order therefore fails. The writ petition is dismissed with the efforts of clarification regarding payment of subsistence allowance. In time of the view, the petitioner is entitled to receive his full salary during the period of suspension. The same minus what he has actually received, such and such, shall be paid to the petitioner within 6 weeks. Insofar as my writ petition is concerned, the other writ petition, Milord 207, 1972 rules do not require approval of suspension order by the West Bengal Board of Secretary. Hence, the order dated 6 October 2015 passed by the board is of no consequence, since the board had no authority or power to approve or disapprove the suspension order in question. The order dated such and such is nullity. On this application, on 11th April 2016, an interim order was passed directing the parties to maintain status quo qua the disciplinary proceeding instituted against the petition. From time to time, such interim order was extended, and by an order dated such and such, the interim order was extended until the further order. I am of the view there is no reason to stall the disciplinary proceeding. Hence, the interim order stands vacated. It is expected that if the respondent authorities intend to continue with such proceeding, they will conclude the same at an early date and preferably within 6 months from date. So both the writ petitions and connected applications disposed of. Now, from this, Lord, an appeal is carried to the Honorable Division Bench. The order made by the appellate court is page 89.
Yes.
Lord, today I invite straight with page 90.
Yes.
We have been informed by the learned counsel, but this is only to the extent of subsistence allowance issue. The school preferred an appeal. We have been informed by the learned counsel for the writ petitioner that the writ petitioner so far received such and such of the last monthly pay drawn towards subsistence allowance till 2018, and thereafter in accordance with 2018 rules, payment was made. Since all dues calculated at the rate of 75% last drawn pay have been paid to the petitioner towards subsistence allowance, till the new rule has come. Thereafter, in accordance with 2018 rules, subsistence allowance is being paid. The impugned order shall remain state for a period of 12 weeks until further orders. It is made clear that the respondent authority to continue pay subsistence allowance, etc. I mean, this was passed. This 12 weeks period is long over. There is no formal extension to the best of my knowledge. To the best of my knowledge, the appeal is kept pending. Now, in the meantime, I demit office. Now, in connection with the other writ petition, that is of the school, I have filed a supplementary affidavit, which is a part of this writ petition which I have annexed. Well, please take the trouble for the present, Milord, your Lordship will kindly ignore that supplementary affidavit. We shall place it. Milord, first is Milord, please come to page 142. Milord, rule.
Yes.
142 it begins. 142 is the relevant rule today. Milord, I very kindly, Milord, invite my Lord to page 146.
Yes.
The board may authorize any officer not below the rank of SI to conduct preliminary investigation against any teacher or non-teaching staff upon receipt of a complaint pertaining to the misconduct of a teacher and non-teaching staff from the committee or the administrator or head of an institution. If the preliminary investigation report reveals prima facie a case of misconduct, the board shall issue a show cause to the notice to the concerned teacher against whom the complaint has been made in order to enable him to explain his act or omission in question by such date as may be specified in the show cause. If the explanation is not satisfactory, the disciplinary authority shall initiate disciplinary proceedings against the concerned teacher or non-teacher, provided that no disciplinary proceeding shall be initiated after 3 years from the date of alleged misconduct becomes known to the board. However, the said period may be extended with the approval of the state government in appropriate cases, provided further that in case of retired teacher or non-teaching staff, disciplinary proceeding with the approval of the state government be instituted within 3 years from the date of retirement. If the misconduct becomes known to the board after retirement. So, looking into the rules. My lord, admittedly, I am accused of some events which took place in 2015. In 2015, my initial suspension order is 14th May 2015, that is at page 50. Yes. Then, not rightly, wrongly, the board accorded its approval at page 64. At page 64. Yes. Please come to page 66. Lord, kindly sees the brief facts. This is the board's order. Though it has been set aside by the coordinate bench, but Milord kindly sees what the board records. The managing committee of the school brought the following allegations against Sri Shumit Sodhikari, headmaster. Milord kindly sees 1, 2, 3.
Financial irregularity
Yes.
is also there.
Under the circumstances, the matter, the managing committee of the school in its meeting held on this resolved to suspend. Heard the parties at length, findings. Well, ultimately, paragraph, page 67, third paragraph from the in the middle.
On scrutiny.
On scrutiny, it is evident the allegations that leveled against the headmaster of the school being serious in nature. And as he is the custodian, his presence would prejudicially affect the proper conduct of inquiry, and as such, the order of suspension passed by the school authority is totally justified in the interest of schools. So, my first submission to your lordship is the board is not in the dark regarding my alleged complicity into certain events. Now, if your lordship sees, the board in the self-same order has directed the DI of schools, AC Nodia, to make an inquiry and submit a report to the board. Now, if the DI of schools takes 10 years to react to this, that is not my fault. Now, rightly, wrongly, suspension, Justice Banerjee's order, everything, ultimately, the rules have been superseded. Now, Justice Banerjee records that this order of the board is bad because I was not governed by the 1969 rules. Approval under Rule 28.9.7a of the 1969 rules was the procedure for seeking approval of suspension in case a teacher is governed by the management rules of 1969. As on date, my lord, management rules of 1969 have been completely, my lord, have gone from the statute. Yes. And it has been replaced by the 2018 rules to the extent of initiation and, my lord, to the extent of continuance, to the extent of conclusion. Everything is governed by the 2018 the appeal rules, or whatever rules it is known as. All disciplinary powers. Pausing here for a moment, I invited my lord to page 67. Why? Because the board was in the know-how of my alleged misdemeanor, if at all. Now, my lord, please fall back to the rules once again.
You are suspended in 2015, prior to 2018.
Yes, but thereafter, my lord, your lordship's court intended that since the 2018 rules have now come into play, I will be proceeded, if at all, under the 2018 rules. My subsistence allowance also would have to be paid under the 2018 rules. Because the 1972 rules did not contemplate, my lord, a reduced pay of subsistence allowance at the material point of time. Now please fall back to 146.
However, 3 years has already been elapsed and they did not initiate any disciplinary proceedings against you. Ultimate result.
They will take this plea.
You have been permitted to retire.
Yes.
Yes.
Now, my lord.
Now a criminal case is going on. Now the issue is
retirement is 31st May 2023. I have demitted office.
Yes.
31st May 2023. Now, my lord.
With provisional, with subsistence allowance.
Subsistence allowance I am showing.
Now till the date of retirement, you drew subsistence allowance.
Yes, till my last day of
last date of your service. Now you are getting provisional pension.
Yes.
Now criminal case is pending.
Only criminal case?
Now the only
means today the criminal case is taking, my lord. It will take another 10 years to prove.
Yes.
There is no endeavor.
Yes. Now question is whether during pendency of this criminal proceedings, any direction can be given to pay the residual part, including full pension or provident fund, etc.
But to that, my first submission to your lordship is, Lord, I just want to show your lordship one thing. Please come to 146. Lord, the first proviso to Rule 5.3.
Yes.
Your lordship reads it, your lordship.
Yes, yes. Yes, 3 years from the alleged misconduct known to the board. So 18, they have...
Assuming 18.
No, they came to know about the fact in 2015
itself.
15. So the pure fixed year expired in 2018. 18 years.
Then, my lord, next.
After retirement.
After retirement.
Retired in 2023. The 3 years has not yet gone. Though board has not initiated any proceeding. So, after the date of retirement, your lordship. So, retired in...
Mrs. Bhattacharya is jumping, my lord, which is correct. Let her, my lord.
Mr. Bhattacharya, Mrs. Bhattacharya, second proviso is applicable in case the misconduct and knowledge regarding misconduct is acquired after his requirement. After his retirement. Yes.
Well, he retired in 2023.
23, but you got the knowledge regarding his misconduct in 2015. So in that case, the first proviso will be applicable.
Well,
second proviso cannot be made applicable.
Not sure. But your lordship board has not initiated any proceeding. So, my lord, whatever is here, it comes only if boards initiate a proceeding after his retirement, whether which proviso will apply, that will come. Here, my lord, board has not yet initiated
any proceeding.
There is no proceeding. So, there is no proceeding. So, my lord, only question remains whether the pending criminal proceeding, my lord, where it is involved in service and defalcation of money during the service. So, whether pendency of criminal proceeding is
defalcation, let them go and prove it.
So, asking them not to. Due to the pendency of a criminal proceeding, your lordship, whether your lordship, he is entitled to the, because your lordship, if he is convicted, then what will happen? So, that is the only question. During the pendency of criminal proceeding, whether he is entitled to get the entire pensional benefit or not. That is the only question before you.
Now, so defalcation of money amounting to rupees?
There is no
charge must be specific.
The board has not issued charge sheet. That is in the criminal proceeding.
No, criminal case.
But that my learned friend can reply.
Criminal case.
Charge frame.
That my learned friend can reply, my lord, what is
they are the de facto.
It would not be happened. You have committed theft of certain amount of money. No. Charge is to be said you have committed 1,000 rupees.
Yes.
An amount of money, amount of rupees 1,000.
Well, board
Charge must be specific.
Lordship. Well, board is not in a position to reply because board has not issued the charge sheet, not procedure. So, well, it is a petition. No, petition. School may only reply, but because school has got the charges.
So there is a, in this way, so there is a alleged financial loss suffered by the school authority.
School authority can reply what is the amount, what charge they have made against him in the criminal process.
Who made the FIR? School authority.
School authority. He can make.
Whether in the FIR it was specified that such and such amount was misappropriated by the petitioner.
Two amounts. But misappropriation of CWS and toilet fund. Handicapped people's toilet.
How much?
1,30,000.
1,30,000, yes.
While he was in jail custody, he withdrew 63,000.
During his stay in judicial custody, he withdrew.
Yes, Malad. Through ATM or any other source, from any other source, Malad, 63,000.
So total
2 lakhs.
2 lakhs.
Almost 2 lakhs.
2 lakhs. What is the amount of his gratuity? What would be the amount of his gratuity?
Perhaps 12 lakh.
12 lakh. And Provident Fund?
Provident Fund he has received.
Provident Fund has received.
Provident Fund he has received.
Another aspect, yes. Provident Fund I have received paltry amount.
That relates to money only. But there are serious other allegations against the headmasters because initially he was suspended while he was performing his duty from his home without coming to the school. He was performing his duty as headmaster from his home. He has taken all the school records to his home. So after suspensions, he was not returned back those documents. School authority made several prayers to the headmaster. But he did not return back those documents. I approached this honorable court. This honorable court.
No, what is your case? Under which provision? The criminal case under which provision? Whether 406 is there. It is old act. The case was under the old act. Whether 406 is there. Must be 406 is there. You could have get a search warrant from the court.
No, what happened, my lord? I approached this honorable court. This honorable court directed the headmaster.
This honorable court, that apart, you should have approached before the magistrate with an application.
I'm coming.
Praying for a search warrant. Then police would get
a search. What happened, my lord? I approached this honorable court. This honorable court, considering all the aspects, directed the headmaster to be present in the school for opening the padlock of those almiras. That intimation was given to the headmaster. He was not present. In presence of the DI's representative, in presence of the police representative, all the almiras are opened. A seizure list was prepared. After preparing the seizure list, so many documents are missing. We also prepared a list. What important documents are missing? Can you see?
What important documents I don't want to know. What left are there to be recovered? What more is to be recovered from the accused person?
Yes.
What more?
Money or documents?
Documents.
Yes, this is the list.
Yet to be recovered from the person.
That's why my writ application. That is why my writ application for returning back those documents.
17 numbers of documents you have still withheld.
Yes.
It is the allegation, Mr. Bhattacharya.
17 type of items, not 17 numbers. Can you see? Go through the list once.
Have you annexed these documents with this petition?
Yes, my lord, I filed a supplementary affidavit. I filed an affidavit, yes. In his case, no, in my case, my lord, I filed.
Now you show me the charge sheet of criminal case. No,
Lordship, may I take your Lordship's leave? Lordship.
you want to take leave?
Lordship.
Okay.
আমি দেখছিলাম পঁচিশ কোন সেকশনে আছে
506, 448, 323।
500,
506, 307,
326, 307.
506, 323.
So there is no 406. There is no 406. The wrongful confinement, thereafter assault, attempt to murder case, such and such. Then threaten. It is the allegation. Now there is no case on from your friend, the breach of trust. The headmaster was entrusted with the and he was given some documents was kept in his custody. So there was an entrustment. You could have made an case under section 406.
No, there is a, this is one of the cases. Just give me 2 minutes. Yeah. And in the other, there is another criminal case. On the complaint of the president of the school, where it appears that 406 has been added.
So 406 is there, Mr. Bari. So you could have made an application under section 94 of the CRPC, obtained a search warrant, that this is the, you give the particulars to the magistrate, that this document was entrusted with this person. According to you, it is stolen property.
Under the management rules, the headmaster is the custodian of all the records. But while leaving the school, he is duty bound to hand over charge and to submit those documents with the school authorities. It is his duty. He was performing his, at the very outset I've said he was performing his duty from his home with those documents. Repeated reminder, no response, or school authority suspended him. Thereafter, no.
Why? Maybe I am not going to inquire into the what he has done. Why I am asking, the purpose is only to ascertain which claim you may have, even against one retired headmaster. So you can claim at best rupees 1,93,000 along with interest and some documents.
Yes.
It is your fault.
Yes, that is our claim.
It is your. So the financial claim which you have made against the retired employee is the 1,90,000 and accrued interest till the date of realization. Maybe. And these
documents.
Except this nothing.
No one.
It is a quantified as a money value, liquidity, then how much will tell? At best, you can be given liberty to you without the gratuity, give the pension.
That the state government can say. Now, in the management rules, there is a provision until the criminal case is, since the criminal case is pending, but he cannot claim the regular pension, only the. And
what is that?
Yes, the book is not with me today, Malat. Can you fix another day? I shall.
Where is the rule? Now maybe I am not school authority and state board, everything.
Which provision the authority can.
So you are withholding 12 lakhs. withholding 12 lakh.
Not I am, my lord, the state authority.
Authority response,
My
respondents.
Not the board. Only the
State. State is withholding the amount of rupees 12 lakh.
না না ডিসিআরবি রুলস এরই একটা পার্ট আই যাচ্ছে না না ডিসিআরবি রুলস হেডমাস্টার ম্যানুয়ালটা নেই
Headmaster's manual.
Okay, so how come you also try to find out any judgment or any authority whether during pendency of the criminal process, and this is the they are claiming that you have to hand over certain documents to them, and you have allegedly misappropriated 1,93,000.
And it's not the state is different. Because state is regarding this.
So let the state come.
I'll put Mr. Bhaskar Boisho for the state on notice. Keeps it on 14/13, subject to your lordship's gracious convenience. May not say.
Mr. Bhattacharya learned. Yes, from
DCRB rules clause 19(5).
DCRB.
Yes, my lord. DCRB rules clause 19 subclause 5.
Yes.
Final pension, gratuity, etc. shall not be sanctioned to an employee against whom departmental judicial proceedings have been instituted or continued. Final pension, gratuity, etc. shall not be sanctioned to an employee against whom departmental judicial proceedings have been instituted or continued. In case of misconduct of the petitioner, the pension sanctioning authority has the power to withhold the pension or reduce the pension. Where any departmental or judicial proceeding is instituted or where a departmental proceeding is continued against an employee who has retired on attaining the age of compulsory retirement or otherwise, he shall be paid during the period commencing from the date of his retirement to the date on which, upon conclusion of such proceeding, final orders are passed, a provisional pension not exceeding the maximum pension which would have been admissible on the basis of his qualifying service up to the date of retirement, or if he has under suspension on the date of retirement up to the date of immediately proceeding the date on which he was placed on suspension, but no gratuity or death cum retirement gratuity shall be paid to him until the conclusion of such proceeding and the issue of final orders. Absolutely clear, madam.
So Mr. Bhattacharya?
Yes, I've got the provision. I'll come back.
Not only disciplinary, judicial proceedings also.
If that law cannot be, with respect, it has to be interpreted to the benefit of both the parties. If a proceeding is continued, for an endless and ceaseless period of time, that has to be preempted. Some measure has to be taken so that a person without whatever has fallen from your lordship. If today it is more of a political thing, I do not want to say it, but if matters can be looked at from this angle that the person at least survives. Today he is getting a paltry amount. Anyway, we'll answer your lordship on this particular aspect. Your lordship is kindly keeping it now.
Hey, কবে দিলে? কবে ফাঁকা?
16 May 2 p.m. I will put Mr. Boisho and Mr. Chatterjee once again on notice.
16 May at 2 p.m. Okay, next. Next.
89 for school authority. 90 for petition.
Item number 7.
So had had the learned advocate just repenting the respective parties কারণ নাম করতে হয় at length. ঠিক আছে? Next.
But I am for the petition.
Tomorrow. So not today.
He has also requested.
এই কিরকম লিখেছেন এই 87-90 হ্যাঁ yes
Item number 8.
Not my application. I appeal with the petitioner. May I file my affidavit of service, Madam?
yes
May I file my affidavit of service? It's a very unfortunate and unique petition, if I say so, my lord. It involves, the lease involves, my lord, the fraudulent, my lord, change of a decree passed by the additional district judge in Barakpur. The signed signature of the judge remains, the decree changes. My lord, just before I start, my lord, may I just, in a nutshell, very nutshell, my lord, I tell your lordship the facts.
you want replacement of removing the false and fabricated judges
That has been found
and replacing the same
by the original decree.
by
Yes.
go to 227 jurisdiction.
No, my lord, there has been, my lord, there.
Don't waste time.
No. My lord, there has been.
When you are filing.
My lord, kindly see.
2022.
No. My lord, this has been, these are other ramifications, my lord. What happened? My lord, my client filed a title suit claiming a declaration in respect of a property. Now, my lord, that suit was ultimately dismissed. From that, my lord, she preferred an appeal. The appeal, the district judge.
Why are you narrating the fact?
No, because when it was.
Again, no.
My lord,
The court has raised first point that there is a supervisory jurisdiction of the High Court over the district judiciary and all courts of district judiciary.
No.
That if anything happened, you invoke the supervisory.
No, now, my lord, this original decree is lying with the registry of this honorable court. Learned district judge possibly cannot.
Whatever it is.
No, because
High Court is court of record.
No. There is an inquiry going on by the High Court.
Don't waste time.
There is a single, kindly says,
You are Mr. Agarwal. No, you're
No.
Lordship,
No, my lord, kindly see. Pursuant to my complaint, as soon as it was discovered that there is a fraudulent.
Again, you are going into the fact.
No, the single member committee was constituted by this honorable court, my lord, Manoj Justice Boshak. Before him, my lord, the disciplinary proceedings were initiated against the presiding officer. He filed a written statement, all are here. Wherein, my lord, he said he submitted, yes, the original decree, that's the decree passed by him, and the decree which was in complaint of was never authored by him. So now, in fact, remains that only thing, the original certified copy and the original decree is lying in the registry of this honorable court, pursuant to that complaint. So all I want is that should be replaced, the direction upon the registry, my lord. I have made them the party. The only thing, my lord, it is lying here before this honorable court. The district judge possibly cannot direct the registry, my lord, to replace the decree, the fraudulent decree, by the original decree, which is lying in the registry of this honorable court. It is lying. There is an inquiry. An inquiry is going on. He has submitted his written statement, my lord. These are all here. Kindly looks in the written statement, my lord.
Mr. Nundi,
the only thing, my lord, that's
you are not giving answer.
What they have done,
whether any act done by any judge while discharging his judicial function can be amenable to judicial review.
My lord,
again you will go on to the fact.
No, only thing what I made a complaint before this on the registrar.
Why are you wasting the time? You filed 227. I am giving you liberty.
all I want.
What judge has done? Any judge of district judiciary cannot be challenged, cannot the same, again, excuse my repetition, cannot be stated to be amenable to judicial review. So every order, every action, against every action only to will be filed.
No,
read, if you say 227 is read, then read lies, but 227.
No, but here, my lord, it's a different case, my lord. Judicial, I am seeking on 227, my lord is, my lord,
Yes,
possibly thinking of.
superintendent jurisdiction.
Yes,
but can do anything. 227 wide power.
That judgment.
Wide power
One of
can
the-
direct that yes, I have arrived at a conclusion that this judgment and degree is wrong, and it should be replaced by the correct judgment and degree.
Yes.
Yes, so go.
And my lord, my second prayer is that to take action.
Withdrawn with liberty to file.
My lord, only thing is, my lord, my instructing advocate is not, his mother is expired. So kindly keeps it
No
on.
instruction is it.
No, I'll talk to him. Kindly give it tomorrow, my lord, at first. Item number one.
Okay. I am not giving any burden. It is my determination.
Only thing, my lord, maybe, well, I'll be seeking leave.
As his representative petition was filed, seeking a direction upon the judge. আইটেম নট দিস উইক বলে গেছে সকাল 11 দাদা
High Court administration.
আইটেম নাম্বার 11 কেউ নেই
My lord,
Chair, beg to represent the
I am praying for not this week, my lord.
নট দিস উইক নট দিস উইক
My lord, earlier occasion, the cost will be deposited.
হ্যাঁ
The cost will be deposited to the.
Court deposited. Acha. Document submitted on behalf of the petitioner showing deposition of cost in terms of the order passed earlier in this petition because it's taken on record. The document submitted on behalf of the petitioner. As a showing deposition of the cost who is the petitioner? Ashish Kumar Chowdhury, Rajiv Ghosh BBP. এই নিন রিপোর্টটা নিন report filed in form of affidavit on behalf of the respondent is taken on record. So what can be done? Next. This is a matter that the restoration application.
Oh, yes, yes.
I moved, my lord, I have filed one application.
Only one
for
application.
clarification of the.
Who is your other side?
the delay, my lord.
Sharp.
Yes, I have filed.
Okay.
খুলে দাও, খুলে দাও। সব করা আছে, সব করা আছে।
It is can 1, restoration, and that is can 2 most probably. এই can 2 টা বার করতে হবে, বুঝলেন? Okay, give me your copy, can 2 copy. Okay, you will take back after signing the order. Acha, can 2 of 2022, yes. Acha, despite service not appears on behalf of the respondent, stop. Heard the learned advocate repenting the. Acha, having heard the learned advocate appearing for the petitioner and upon perusal of the averment made in the application explaining the delay in preparing the application for restoration, comma, I am satisfied that the sufficient cause existed which prevented the petitioner from filing the application for restoration. Got it. Application for restoration within the period of limitation provided therefore. Stop. Accordingly, the application is allowed, delay is condoned. Delay in preparing the application for restoration is condoned. এবার তলায় নামুন can 1. Stop. আচ্ছা, এটাও ছোট করে। আচ্ছা, this is an application for restoration. Stop. Having heard the learned advocate appearing for the respective part, appearing for the petitioner, and upon perusal of the averment made in the application, I am satisfied with the explanation provided towards non-absence of provided towards the absence of the learned advocate of the petitioner on
4th March.
On 4th March 2024, comma, when the writ petition was dismissed for default. Stop. Accordingly, the application and allowed dated 4th March such and such is recalled. The writ petition is restored to its original file and now. ঠিক আছে? List the matter for further consideration when?
Next month,
আচ্ছা, in the monthly combined list of June. ঠিক আছে? আচ্ছা, তাহলে এইখানটা কেটে দিন তো। আচ্ছা, লাস্টেরটা করে দিন তো, লাস্টেরটা লিস্টটা কেটে ওটা কেটে দিন। আচ্ছা, petitioner is directed to serve a notice to the respondent intimating that the matters that the writ petition shall be placed. Oh, you are for the respondent. Okay, I allow the.
Next month,
তাহলে ওর নামটা লিখে দেবো, রজতের নামটা লিখে দেবো। Having heard. Mr. Roy. So list the matter, last this. List the matter for further consideration in the monthly combined list of June 2025. Next.
Your Lordship, my learned senior Mr. Ujjwal Rai is appealing for the petitioner. Your Lordship, I am humbly praying for 1 day's accommodation, Your Lordship.
This one number
So not to.
Gratefully.
ঠিক আছে
16 বলুন দেখো।
My lord, in item number 16, I am appearing for respondent number 3, my lord.
Oh.
And I am appearing for the state respondent, my lord.
No appearance through virtual mode will be accepted.
My lord, grateful, my lord. I am grateful, my lord.
Who is the for the petitioner?
My lord, appearing Jonardhan Mondol. I am for the state respondent, my lord.
So at the bottom of the list. At the bottom of the list.
My lord.
Yes. So none appears, what do you want?
My lord, for respondent number 3, my lord.
Okay, একটা অর্ডার করে দিন। আচ্ছা, petition none appears
on behalf of the petitioner, nor has any accommodation been sought for. ঠিক আছে, though Mr. Dale, Mr. বিশ্বাস, and Mr. Bosu, Mr. Bosu, learned advocate, representing the respondent, is present through virtual mode.
But I'm appealing for the state respondent.
Just stopped and onar naam to likhe. Mr. Bosu is present. Learned advocate representing is present.
I'm grateful, Your Worship.
Stop. However, to afford another opportunity to the petitioner to appear, place the matter in the combined monthly list of June 2025.
I'm grateful.
Next.
My lord, grateful. Your Worship.
Next.
My application, Lordship. Very
17.
short point is involved, Lordship. In the common inquiry, common disciplinary proceedings, one article of charge, Lordship, the charge that was not proved beyond any reasonable doubt as per the findings of the inquiry officer. He moved before this honorable court. This honorable court was pleased to direct, Lordship, by quashing the order passed by the disciplinary authority as also the appellate authority, Lordship, at page 283, Lordship, passed by Honorable Justice Jayanta Kumar Bishas, Lordship.
What is the charge against you?
Only, Lordship, fail while working as technical assistant grade 1 at Food Storage Depot, Food Corporation of India at Kollani, Lordship, failed and neglected to undertake a curative and prophylactic treatment of the food grains. Lordship, charge sheet was issued against the petitioner along with 9 other charge officials, Lordship. Thereafter, Lordship, the inquiry findings, Lordship, kindly come to at page. Lordship, kindly come to the first order. Order passed by Honorable Justice.
Order means order of the final order of punishment.
Final
That
order.
order has been complete. May I just?
No,
short
Lordship.
the-
No, that
shorten
was
the matter,
quashed, Lordship. No,
One
quashed,
initial
Lordship.
order was passed, my lord.
That was
Inquiry
passed
officer
by
did
this
not find any fault with the allegations, my lord, level against the delinquent, my lord. But the disciplinary authority disagreed. Yes, and imposed a punishment. Since my lord disagreement memo was not given to him, my lord, therefore the writ petition was filed. So therefore, my lord, by this by the order of the honorable court, my lord, again, my lord, an opportunity was given to him to provide his further representation. The representation was to the delinquent, the charged officer. One second, because my lord, the inquiry officer did not find any fault in the allegation. But the disciplinary authority, my lord, knows it is a settled position, it can disagree.
So he didn't file his statutory appeal?
Yes, but
Appeal,
thereafter,
Lordship, that
thereafter,
was 5 years time, Lordship.
when he disagreed, the settled position of law is this, my lord, when the disciplinary authority disagrees, then another opportunity is to be given to him.
Should be given, yes.
To
That
again,
was not given.
That opportunity has not
initially that
been
was not given. So
Yes.
because of this order, my lord, again we gave the opportunity.
So final order was set aside.
Yes, my lord, the final order given, the
Modified?
punishment was given, my lord. Again, the appeal was done. Appeal was also affirmed, my lord. Review was done. Review also affirmed, my lord. The present position is this, my lord. The pay scale of this particular charge officer has been, my lord,
Reduced by 1 stage, Lordship. What happened, Lordship? The
So
reviewing
their
authority,
punishment was reduction of pay.
reduction of pay,
a minor penalty.
Lordship. What happened, Lordship? The reviewing authority as also the appellate authority administered by one post, Lordship. While the reviewing authority is the chairman, Lordship, the appellate authority is the managing director. Both are same and the one post, Lordship.
No, these are, my
But-
lord, wrong
no,
submission. my
Lordship.
lord.
No,
These are wrong submission.
In the meantime, whether there was an amendment.
No.
No, my lord,
Amendment
this
of
is not the case, my lord.
Huh?
It is not the case. Executive, my lord, director, ED is one authority and chairman and managing director is another of. The highest authority is, my lord, the chairman, managing director. In particular, there are 5
No,
zones,
the
my lord.
managing director rejected the appeal and chairman rejected the review. My humble submission, reviewing authority must be superior to the rank of the appellate authority.
That is
Lordship.
there, my lord. That is there, my lord. Perhaps my learned is missing something. There are 5
No,
zones,
no.
my lord. East, west, south, north, and southeast. In each zone, my lord, there is an head. That is called executive director. And in top, when all India
Okay,
level.
allow him to place his
Very well,
case
my lord.
first.
Very well. Then I am, my lord.
Yes.
Lordship, can we come to
Since it is a
last
factual
page,
error, my lord, that is why I pointed out.
Lordship, can we come to at page 336? That is the
So
last page.
first give answer to the query. What was the charge?
Charge was, Lordship, while working as technical assistant.
Technical assistant.
Grade
Yes,
1 at Food Storage Depot, Kollani, Food Corporation of India. He failed to undertake prophylactic and curative treatment of the food grains, Lordship. And As a result, Lordship, wheat was downgraded from A and B category to C and D category, and FCI sustained loss. Lordship, that very article of charge that was issued against the petitioner and 9 other Food Corporation of India officials, Lordship. One common disciplinary proceedings, common joint inquiry proceedings, and inquiry findings, Lordship. The charge has not been proved against the petitioner and other 9 charged officials, Lordship. The disciplinary authority imposed penalty. Thereafter, he preferred the appeal. On the last occasion, when he approached before this honorable court was pleased to set aside the order passed by the disciplinary authority as also the appellate authority with further direction upon the disciplinary authority to conclude the proceedings as per findings of the inquiry officer. Thereafter, Lordship, again disagreement notice which was issued after his retirement, Lordship. In the meantime, since in terms of the performance appraisal, Lordship, he was promoted to the post of manager quality control.
In the meantime, he was promoted.
2008, he was promoted to the post of manager quality control, Lordship. What happened? His contention at that time, when the fumigation, that is the downgradation was started, he was not there at Kollani. He was posted at Kollani on and from January 1995 up to December 1999. And as per their contention in the affidavit in opposition affirmed by FCI authorities, their contention that fumigation and downgradation that was started on and from May 2000, Lordship. And Lordship, thereafter, when the disagreement notice issued after setting aside of the earlier disciplinary penalty,
Final order of punishment,
Lordship, when disagreement notice was issued after his retirement, and Lordship, he preferred the appeal. That appeal was rejected, Lordship, after 5 years from the date of preferring of that appeal, and thereafter the reviewing authority, they took, Lordship, 3 years time for dismissal of the review petition affirming the order of the appellate authority. When the regulation 60 says that after retirement that proceeding should be concluded within 1 year, Lordship. And what it is said, Lordship, in the reviewing authority order,
whether there was any default clause.
Lordship,
Timeline was fixed by this court.
Huh.
Whether there was any
No.
default clause.
No.
There was no default clause.
Lordship, can we come to at page 336, Lordship, last page.
Page 36.
336, Lordship, last page. That is the order passed by the chairman, being the reviewing authority.
Yes.
Moreover, Lordship, from the top, Lordship, moreover, a minor penalty in the instant case was imposed upon the petitioner by the disciplinary authority, and as per the extent instruction, the personal hearing is allowed in the cases where major penalty is imposed. As such, contention of the petitioner in this regard are not tenable. It is seen the petitioner has contended that the downgradation started from May 2000 and he was transferred. Downgradation started from May 2000. They admitted in their affidavit in opposition, Lordship, and he was transferred from FSD Kollani on 31/12/1999. It is seen that his contention has already been examined suitably by the disciplinary authority, that it could not completely absolve his responsibility in the matter as the quality of stocks could not deteriorate all of a sudden. His contention referring the order dated 24/5/2005 of ED East is not tenable as it pertains to different depot, that is FSD OGM, and each case is decided on its own individual merit, Lordship.
Based on
facts, evidence on record. Further, I am also in agreement with the view taken by the disciplinary authority in the matter that the inspection report of Joint Commissioner S&R referred by him cannot be construed as real fact of downgradation, and the same does not give license to the petitioner to remain idle and shift the responsibility to others. It is on record that the stocks under question remained untreated or unfumigated for a long period. It is seen that appellate authority has judicially held in the matter that various problems highlighted by him act as constraints in the quality control operations but do not justify the complete cessation of QC operations during the period and lack of any substantive efforts made by the wing in association with the depot staff to alleviate the situation. It is a matter of record that a quantity of so-and-so MT wheat downgraded to C category and 13,479 MT wheat to D category due to failure on the part of the petitioner and other co-accused, leading to huge pecuniary loss of so-and-so. My humble submission, Lordships, they are not relying on their own report, Joint Commissioner's report. That is annexed, Lordship. That was done due to the deplorable condition of the go down, Lordship. That is evident from the report of the Joint Commissioner SNR at page 159, Lordship. What it is said, Lordship?
Yes.
Lordship, point number 2. It was observed that stocks in most of the godowns, particularly fresh wheat stocks from up north, have been stacked even on the allways, making it difficult for even to enter into the godown. What to speak of undertaking prophylactic or curative treatment. Heavy inflation of major pests such as so and so was noticed in almost all the godowns. Lordship, lot of documents are there in the inquiry proceedings which are produced before the inquiry officer, Lordship, which will reveal that he was not at all responsible for the Lordship, for the loss sustained by the corporation, Lordship. Moreover, Lordship, one point that the appellate authority is the managing director, while the reviewing authority is the chairman. And Lordship, my humble prayer, the reviewing authority must be superior to the rank of the appellate authority. And Lordship, no reasoning is there why they are different from the findings of the inquiry officer, Lordship. It will take some time to finish, Lordship. Tomorrow.
Or if my lord kindly fixes a date.
Tomorrow, Lordship. Tomorrow.
But tomorrow I have difficulty in the coming week as well, my lord.
Again, Lordship.
If time permits, my lord, after vacation, my
No. Lordship, 3 times he was affected by cerebral attack, Lordship. 74 years old, Lordship.
Item number? Yes.
Tomorrow, Maharaj, I will be going for medical checkup. That's why I have breakfast.
So not this week?
Lordship, the affidavit in reply, Lordship.
Everybody reply to me. So not this week.
It will be coming on 13.
Not this week. It is HON'BLE. It has been placed returnable matter. Thereafter, one day upgraded matter will be placed first. What can be done in this way? It will be taken up. Don't worry. It will be taken up. It will be. I'm not this week. দেখবেন এটা এটা রিটেন করে দেবেন রিটেন okay, it will be retained in its position.
Next matter, my lord.
It will be retained in its position.
In next matter, 18, my lord. They have submitted a report, my lord. Pension matter, my lord. You'll actually take up tomorrow.
Who is your petitioner?
18.
I am for the petitioner.
18. I am for the state, my lord. Report is ready, my lord.
Ready, my lord. Only for one point, my lord, withdrawal. They have not deducted my amount from the withdrawal as a withdrawal.
Come tomorrow, 18.
18. Stop, my lord.
18 টা জানো।
Stop it.
Oh.
না, পরেরটা ছিল। পরের ভাই যাচ্ছে।